is a request that they ask if they could please remove the jackets. Yes, most certainly, yes, yes. Thank you. I believe there's a request to remove your jackets. Please feel free to do so. I was very, very hot for 3 days now in a row. I believe it's quite warm today as well. Yes, so you're welcome to do that. Let's dispense with the formalities for the sake of our health and our sanity. We're on our 3rd day without air conditioners, very bad. And at my age, I most certainly do need air conditioner. Thank you very much.
It sets out the 2 main issues which I'm going to be arguing. First page deals with effectively one half of the argument, and what we submit is the only real issue which confronts this court. And that's the question of what are the practical consequences of this court granting the order which the applicants ask for. What will be the consequences of granting an interdict, and what will be the consequences of not granting the interdict? And we submit the answer to that question resolves the case before the court. I will, however, also go on to another part, and might I say this, that the applicants hardly dealt with that issue, the central issue. Every time your ladyship put questions in that regard, they were unable to answer them. Their argument focused on the prima facie right, and particularly their right to review. So I'll deal with that second, and that's on the second page of the map. We submit ultimately that that's irrelevant for the issue to be decided by this court. So the first issue, the only issue we submit, what are the consequences of granting an interdict? This relates to 3 of the requisites that need to be decided in law by the court in relation to an interdict. The first is whether a prima facie right has been made out, and that's in particular the understanding of what needs to be made out for a prima facie right in interdict proceedings.
Marie, what happened to my notes? What's there? I don't see my notes. Sorry, I just can't find my own notes. Oh, no, my notes on the case itself. I left it in my file. Just check to this. I didn't put it in the file. Did you put it? Oh, okay, there it is. No. The one that open it? Okay. Yeah, this one. Thank you very much. Thanks.
Lady, your ladyship will see at the top of the mind map, the first branch deals with the practical consequences of an interim interdict, and then the 3 of the requisites are referred to: prima facie right, apprehension of harm, and balance of convenience. And before dealing with the consequences of the interdict, I'd like to relate them back to these legal tests so we know what the legal framework is for approaching the factual issues. Mr. Rosenberg yesterday referred your ladyship to the Alter decision, and I'd like to emphasize just a salient part of that decision because it's critical to the court's approach to this case. In paragraph 50, the Constitutional Court, a unanimous judgment, said, quite apart from the right to review and to set aside the impugned decisions, the applicants should have demonstrated a prima facie right that is threatened by an impending or imminent irreparable harm. So it's not good enough to say there's a review ground established and there's a prima facie right to review. To grant an interim interdict, the applicants need to show that there's some other right that would be affected if the interdict's not granted. And when Mr. Rosenberg was dealing with this point, your ladyship correctly said, haven't the applicants established that there's a right to culture, a right to heritage? Yes, that's correct. There is a right to, it's not disputed in this case. This ground has critical heritage value. The heritage
so that is
rights
exactly what I'm trying to establish. Would that not dispose of the first requirement? Not at all.
No, it doesn't. Not at all.
It doesn't at all.
No, because you have to relate that to the next requisite for an interdict, which is a reasonable apprehension of irreparable harm to the right. And what right is that? It's not the right to review, it's the right to heritage.
Yes.
So
yes.
that's the link.
Yes, exactly.
That's why this point is important. And that's why we start off by showing what would happen if an interdict is not granted. And sorry for the spoiler, the answer is that there's going to be no harm to heritage. And we'll take the court
and
through
that is why I started the proceedings and dealt with the issue of tangible and intangible heritage resource value.
Yes.
Because the way I understand it is that is the crux of this case insofar as it relates to the applicant's argument.
Yes. Yes, indeed.
Yes.
Your ladyship has got it absolutely correct.
Yes.
The crux is, what is the tangible heritage
Yes.
on the site? And your ladyship started off asking my learned friend, what do the applicants want with the site?
Yes.
What's the end point of the interdict? They weren't able to answer that because they
But
don't
I can
have.
tell you why they're not able to answer that. It's because the concept of intangible heritage resource, of an intangible heritage resource, is an abstract term. So what might be considered for one indigenous group as an intangible, as whether it's traditions or poems or rituals, what might be considered as an intangible heritage resource for one group may not be considered as one for the other. So in my research, I discovered that it took some time to actually contextualize a definition for that term. There were over 40 definitions of the term intangible heritage, intangible cultural heritage resources. So then I realized that it might become a problem for the court. That's why I actually went to do some research on it. So the city can say, and I think the applicants also took exception because there is this line in the assessment, the heritage impact assessment report that says there are no current, is it intangible heritage? I think it's intangible heritage. There are no remnants of intangible heritage resources. That is contained in it. And then I asked myself the question, but there's the river, and I tried to clarify it at the outset in this hearing that this court's view is that the river represents both tangible and intangible heritage resources, and it doesn't appear that there's any difference. There's no dispute about it because yesterday, council argued yesterday and also acknowledged the developer, if I can use it, the developer acknowledged that.
Yes.
And the developer did everything in its power to comply with what heritage, which HCW wanted. So we won't criticize the developer. It's more about the concept of intangible heritage. Why is the applicant saying if the concrete buildings, if the high-rise buildings go up 10 stories, two developments would be about 10 stories high, that in itself would be detrimental to our cultural and historic
That's something
history.
that had to
And
be
values.
considered. It's a relevant question.
Yes.
Is that does the existence of buildings in itself
Yes.
destroy intangible heritage?
Yes.
And that was considered in detail by the decision makers. And I'll take your ladyship
Sorry, I
to
didn't hear. It was considered by, I'm talking about the HIA?
whether these buildings
Yes.
will harm the intangible heritage. That is something that was considered, and it's not a new point raised by the applicants. It's something that was very much at the forefront of the decision makers' minds when considering it. The conclusion they come to, and I'll take your ladyship to the
Yeah.
evidence, is that those buildings will not harm the heritage. In fact, the development as a whole will benefit the intangible heritage. And I'll take your ladyship to the evidence of the benefit to intangible heritage of the development. And the flip side of that is that stopping the development will prevent the protection and benefit and advancement and commemoration of that intangible heritage. So if I may move on to
Yes.
the evidence, and then I think that would
I just
address
paused
your
because,
ladyship's
sorry, I
question.
just paused because you said that I was a bit concerned when you argued that my understanding that the first requirement is met because of the concept of intangible heritage. That's how I see it. So I needed to respond to that.
Yes.
They have a right to the protection and preservation of their culture. And cultural heritage would include tangible and intangible, tangible heritage resource. Now, I must simplify the question again because maybe I missed something. What is the city saying? Did the applicants establish the first requirement?
No,
Is the city saying-
they didn't
No.
even address the first requirement. The first requirement, your ladyship has correctly identified the
Yes.
test. And it's, if I may simplify it further, the question is this: will the development harm intangible heritage? That's the crux of the issue. The applicants don't answer that question because they didn't even ask it in making out their case. They asked the question, will the development harm their right to review based on their
I
review
see.
grounds?
Yeah.
And that's the wrong question.
Yeah.
That's the point that the court made in Alto. Was the wrong question posed by the applicants in that case. It was the wrong question considered by the High Court, and the Constitutional Court said that's not the test in interim proceedings. The test is, will the development in this case harm the right to intangible heritage? Will it irreparably harm? And the evidence is that it won't. And that evidence is not only a version, it's uncontested. The applicants didn't even think to contest it because either they had no answer, which we submit as what the evidence is. I think it's twofold. One is that they don't have an answer to that. And secondly, they misapplied the test. They were thinking right to review instead of right to heritage.
I'm thinking, why are you saying the applicant didn't answer the question? Did the applicant not say, oh, I see what you mean. They didn't contextualize it. Yeah, because the project, and that is why I actually quoted from my notes what the developer, how the developer adapted the plans in order to incorporate certain features to comply with the conditions and also to preserve the cultural heritage, be it tangible or intangible.
Yes.
Yeah. Yes.
Yes, exactly. So
Yeah.
the development responded to that. It's
Yes.
part of the engagement
Yes.
process, part of the participation process. It wasn't just a tick box exercise.
Yes.
Let's
Yes.
hear your submissions and we're going to go ahead anyway. There
And
was
one group, we are dealing with two groups, am I right? Those are for the First Nation groupings, for and against.
I don't.
I need you to
it might be-
clarify. I want to know, are we dealing just with two groups here, two or three groups here?
There
Because
might
that
be
would
more than
mean
two, but
there's
we-
not consensus.
We at least have proponents and supporters of the development, including
Yeah.
First Nations groups, and there are opponents who include First Nation groups. There may also be other people
Yeah,
who
no, I'm
are
only
indifferent.
interested in the First Nations groups. That's all. I'm not interested in in people who have no connection to the property in terms of their culture and their heritage.
That is the crisp question, and
Yes.
and there are differences of opinion.
Yes, yeah. So the conditions satisfied one grouping.
No, the conditions aren't aimed at satisfying a group of people. The conditions are...
Let's just talk First Nations.
Yes, so the conditions...
You know, that term is very important. First Nations. Let's just talk about them.
The conditions...
Part of a certain grouping of the First Nations were consulted, the plans were adapted, and those features were accommodated and incorporated to satisfy any concerns raised with regard to tangible and intangible heritage resources.
Milady, yes and no. Yes, well, yes and more. Yes, it satisfied some of the First Nations groupings.
Yes.
But the conditions weren't aimed at merely satisfying the groupings. The conditions were aimed at protecting the intangible heritage of the site. That's the point. And the evidence is that that is not only good protection of the heritage, but it advances the heritage, it protects it in a way which has never been done before. And
Would
it
that
protects
be in compliance with international law?
Yes, complies with the international consultation requirements, certainly because of that adaptation and consideration. And it advances and protects...
I must confess that when one reads, when I read the papers and I see all the features that is going to be in this development, it sounds actually quite impressive when you read it.
It does,
And it
yes.
sounds as if it is fair and reasonable. But when the amici then argued, then I posed the question to myself, would that be sufficient for the First Nations?
Milady, may I come to the question of participation? It's in the latter half of my argument.
Yeah, I'm
certainly
glad
going
we
to-
can get there because that is one of the issues that I'm also
Yes,
concerned
no,
about.
it's a
After
central
hearing
feature.
the amicus. But sorry, I'm interrupting you now. Let's not go to participation. I don't want to disrupt you further. You were busy addressing something that I've raised, and then you can deal with participation.
I'm indebted to your ladyship.
Yeah.
So the point about Alta is that it focuses the court's mind
Yes.
on whether the development will harm heritage, and that relates to the apprehension of harm. And then, in relation to balance of convenience, the court is engaged in a practical weighing up exercise. What would the harm be if the interdict is granted, and what would the harm be if the interdict is refused? And that again considers the consequences. So turning to those consequences, the first question is the first question that your ladyship raised on the first day of the hearing, and your ladyship put to me earlier, is what is the status quo? What are we dealing with at the moment?
Yes.
And there are two parts to that. It's the land use on the site at the time the decisions were made, and that's dealt with in our heads of argument, if I may refer your ladyship to paragraph 20 of the heads of argument. So at the time that the decision was made by the mayor and the province, the River Club site was an exclusive use golf club and an asphalt parking lot. And the evidence from the respondents is that that degradation runs completely contrary to the site's heritage, and it does nothing at all to echo or respect or celebrate the First Nations history and experiences on and around the River Club site. A golf course, parking lot, and concrete rubbish-strewn canal are the antithesis of how First Nations used and experienced the site. Paragraph 22, the mayor explained, the subject property fails the site's heritage. Nothing positive is gained from preserving the status quo. And in paragraph 23, we say that none of this evidence is disputed, and there's references which I won't take your ladyship to. So, in fact, my learned friend said that the golf course and parking lot use are offensive to the site's heritage. So we're on common ground there. What we have now is things have moved on. We now have a golf course which was at least green, even though the lawns were alien vegetation, not indigenous vegetation. That's now being transformed into a construction site. So freezing things at the moment, the status quo does not freeze a heritage-friendly situation. What would be the consequences of freezing the development, of stopping the development and not allowing it to go ahead? That's the question of what prejudice would occur if the interdict is granted. And one needs to then look at the benefits of the development which won't happen if the interdict is granted. And they dealt with, from paragraph 53 of the city's heads. Actually, maybe if we could just stay where your leadership is, paragraph 24. The evidence is that it's undisputed evidence that the development will have the following benefits. The Liesbeek River will be transformed from a polluted concrete canal into a naturalized river course with an indigenously planted landscape. And your ladyship, may I take your ladyship to a record to show a visual image of what it's going to look like. It's at page 1452 of the record.
Which volume?
I'll give you the volume in a moment.
Sure.
Volume 4. One 1452.
Yes, I'm with you. I see the pictures. Yes.
And so these are the images of what the visual impact assessment images, the evidence before the decision makers. So here we see the first image is the green corridor, and this picture is taken, the map shows, is taken with the ones back towards the canal, what is currently the canal and the river. So this is the view from the river towards the Amazon building. And one sees that there's some space between the river and Amazon building, which has indigenous vegetation and it's behind trees. And that's because there's a buffer built into the conditions. So these tall buildings may not be built right on the river. There has to be this green space between the river and the canals, which will be open to the public. And the second image on that, and so this vision of or this picture of what the development is going to result in is far more harmonious with the site's heritage. Then the next picture is various heritage commemoration features. At the moment, there's none of this. If one went to the golf course, one would just see a golf course. No one would know that the site had the heritage. That's going to be changed with the development. And then over the page, milady, does your ladyship have color images? So there's a picture of the rehabilitated river. Currently, it's a canal, and it'll be transformed into a natural river. And that's far more consistent with the site's intangible heritage. And not only are these promises by the developer, these have been incorporated into legally binding conditions. So your ladyship would have seen the decisions that have been made have conditions and schedules, and those conditions then have the force of law through the bylaw. It would be an offence to not do all of this, and it's enforceable. So these are things that will happen. The environment will be rehabilitated, so those are the benefits for heritage. Oh, sorry, I was dealing with the other benefits. So that's the river. That's the first one. So if I may return to the heads, the city's heads, then deal with open space, which is in fact going to be increased. So this is back to the city's heads, paragraph 24.2. The amount of open space will be increased. There will be an establishment of a cultural heritage and media centre, which will be prominently located in the development to capitalise on the views. And this will allow the First Nations history to be recorded and taught in their own terms. And I'm going to come back to this point, but I just want to link it to the following two requirements and aspects of the development. There will be a construction of an amphitheatre for cultural performances. There will be an Indigenous garden, which will be actively used and managed by the First Nations, which will allow their knowledge of food and medicine to be put into practice and so preserved. And those three features are the way in which the development will give life to the intangible heritage of the site, because the intangible heritage is carried in an oral tradition in the memories and lives of the First Nations groupings. At the moment, they lack the space to give expression and to communicate that and to give life to it.
The applicants did not comment on these features.
The applicants were very involved in...
No, I'm saying the applicants in this matter,
Yes.
did not comment on these features to say we are offended by these features.
No.
We don't like this aspect of the development or that aspect of the development. They didn't do that.
No, there's no objection to any of this. There's no suggestion that this undermines the heritage or doesn't give
there's no
proper
such
effect.
suggestion.
And
So
importantly,
we'll
this-
hear from the applicant what their views are with regard to how the heritage, or how the First Nations and their views and their cultural heritage were accommodated, and what the applicants' views are on those aspects that were incorporated, as well as the conditions that were posed, and whether they're happy with the manner in which the developer accommodated the First Nations. I'm just thinking out loud now. I didn't hear the applicant say anything about
No.
the features.
Milady, of course they'll say that they're not happy with this, but...
No, the
but
applicants basically are saying we don't want a concrete jungle.
Yes.
there.
Well,
So the focus was more on the high-rise buildings than the actual park that we see here, and the eco trail, etc., etc.
So
No.
the practical reality is one can't get these features without the buildings. It's part of the development. The development pays for all of this, pays for the naturalized river and the Indigenous garden and the amphitheatre. The solution for the applicants is that maybe someone will expropriate it. It's a pipe dream. It's not going to happen. This is going to happen. These features, which are not only unobjectionable but are indisputably beneficial, are linked to the buildings. One can't have one without the other.
There are no current plans afoot to declare this property as a World Heritage Site or provide provincial protection, or even extend the provisional protection that lapsed as we speak.
No, there's no, the provisional protection orders lapsed. The reference to World Heritage Site, that's never been suggested. I think it's been mentioned, but there's no application or UNESCO would be the body that would grant this. There's no serious suggestion that the site would qualify as a World Heritage Site. The debate has been whether...
Was anything done in the past about the status of this site? Or is it just this development that triggered all... I'm asking this because I'm trying to understand. The applicants will reply later, but did the applicants take any steps to protect this?
No, Your Ladyship, the answer
property,
is Your Ladyship asked that question, that very relevant question. In fact, I was going to deal with it because it's an important question. Your Ladyship put that question to my learned friend, and the answer was, under apartheid, it was not possible for the applicants to do anything. We accept that. However, it's been 27 years since the end of apartheid, and there have also been no steps taken to change the site. And even if the site, so there's a debate about whether it's a provincial heritage, it's of provincial value or national value,
Yes.
but even if such a protection would be granted, that doesn't then transform the site into a pre-colonial commemoration. It simply means that in order for development to happen, a permit is required. So it's a freezing order which doesn't then give anything to heritage. And the obtaining any kind of statutory recognition wouldn't do anything in practical terms to advance the intangible heritage. There is only one option on the table to protect and advance heritage, and that's the development. And that's been the case despite the fact, and I'll refer your ladyship to plans which were supported by the city 18 years ago to declare an urban park. And the city's undisputed evidence is that's a pipe dream. It's there, it's a policy, it's an aspiration, but there's simply no money for it. It's not going to happen.
Now, the city also said that should this development go ahead, First Nations would still be consulted and they would
Yes.
still be able to make contributions. Is that the case, or will the development just go in accordance with the plans and by incorporating the features as stated in the project? Adapted, the plans as adapted?
There is a condition, I think it's condition
Yes.
21,
Yes.
which requires ongoing further
Yes.
consultation about the list of features. And,
Yes.
and that consultation must include at least the First Nations
Yeah.
First Nations group and the second applicant. They're specifically named as people who must be
Yeah, but I would
considered.
imagine that the applicants are saying, but then the high rises are there. We must just be consulted in respect of A till A, B, C, D, and E, but the high rises are there. So I'm just saying that condition would not really assist the applicants with their objection to the high rises.
There's going to, yeah, but the answer to that is that there was extensive consultation
Yes.
about the high rises. And I'll take your ladyship through, we set into our heads of argument.
Yeah, I think I'm
paragraph-
interfering now because my concern is also about we'll get there. Consultation.
The adequacy of consultation and the extensiveness of the consultation is something that
That was
we'll
raised
refer your
yesterday
ladyship
also.
to.
Yes. Yeah, sorry, I'm interrupting you.
So we were dealing with the benefits. There's an indigenous garden,
Yes.
and then indigenous names in sub 6, an eco trail around the development. That will align with the First Nations' deep appreciation of the site's ecology and allow visitors and pedestrians to experience the ecology on foot. This refers to the public accessibility, which will be secured in a servitude on the site. Currently, the public don't have access to the site. The golf course would have been private. You'd have to be a member of that golf course or pay to get in. That's exclusionary. That's the antithesis of commemoration. And
Would all these positive features then impact on the issue of balance of convenience?
yes, absolutely. It's critical to balance of convenience because these are the things which will be lost. The court order, if an order by this court saying the interdict can't go ahead, means that these benefits may not take place. Not only these benefits will not take place because the development will be stalled. And there is no other option, there is no other way to achieve these benefits. So that is a very heavy consideration of balance of convenience. And on the other hand, there is no prejudice that will result if the interdict is refused. So I've mentioned three benefits, three categories of benefits of the development. We've dealt with heritage. The second is environment. There's no dispute about that either. The development will rehabilitate a degraded site and it will improve biodiversity. And the evidence is clear on that. The third aspect, and it's one that is one of the particular reasons why the city is involved in this case at this stage, is the public interest in the development and the development proceeding. The first aspect of public interest is the need for economic recovery in the city and in the country, I suppose. May I refer your ladyship to the record, volume 4, page 1435.
Page 14?
1435.
35.
Paragraph 14.3. Here the mayor is referring to the accompanying affidavit of Mr. Kraling, who's the city's expert on economic matters. And he says in that affidavit, that affidavit explains, the city is in the midst of a fourfold economic crisis. Economic output, construction and confidence are at a worrying low levels, while unemployment is at an alarming and record-breaking peak.
I suppose when it comes to the protection and preservation of cultural heritage, there's no monetary value to be attached to it.
I'm sorry, my lady?
When it comes to the protection of cultural values, cultural tradition, or the preservation of the cultures and traditions,
Yes.
no economic value can be attached to it. And I'm specifically, I did consider when I read this paragraph, I thought, well, whether the loss is 1 billion or 5 billion, how does one weigh that? Should there be some sort of negative impact or some harm to cultures and traditions?
So the notion of weighing competing considerations is one that frequently arises for decision makers in these kinds of decisions, because it often happens that there's a trade-off between development and protection of various rights, heritage, environment, etc. This development has a unique feature in that there is no trade-off. It's not a question of either we get the economic benefits or we protect heritage. This development, and it's undisputed on the evidence, has the very, very happy and favorable feature in that it achieves both.
It balances both.
Sorry?
I say it's a balance. It's a balancing act.
Well, I submit it's not a balance. It's not a balance to say that on the one hand we've got protection of heritage and on the other hand we've got economic advantage. What we have in this case is both of those are on the same side of the scale. On the one hand, on this side of the scale, we've got protection of heritage and economic development. And that's the reason to refuse the interdict. On the other hand, you've got economic deprivation and harm to heritage. And the scale sits like this, milady.
I suppose first prize for the applicants would be that the property be expropriated, which appears not to be a viable option.
It's not only not viable, it's not even a proposal.
Yeah.
The applicant's papers don't even suggest that it should be expropriated. That's something that my learned friend came up with because he had no answer to your ladyship's questions. Your ladyship was saying, well, what should happen to the property? And he said, well, I suppose it could be expropriated because there's a power in the Act. But that's an ocean of difference between a factual prospect of it actually happening or even a request for it to happen. Which government would do it with what funds? How would all of this be financed? The only evidence is that is a pipe dream. It's not going to happen.
So if one removes that possibility, what is left?
What is left is two options, my lady. The one option is the development proceeds with all of its economic, employment, heritage advantages. And the other option is stop the development, stop the economic advantages, stop the heritage advantages, stop the cultural, environmental, and all those other advantages.
But that wouldn't be a permanent stop. That would be just a stop to perhaps pause and reflect and meet each other halfway.
the evidence from the applicant, from the developer, is that a stop for a period of 18 months to 2 years while a review is running would kill the development. So in practice, it would actually be a permanent stop. That's a common feature with objections to heritage at this late stage. Because of the way the finances work, the holding costs make it unaffordable. The development collapses. Amazon moves on to somewhere else because it can't wait 2 years to establish its new office. The financial viability collapses, and none of these advantages ever materialize. That's the undisputed evidence. So it's not temporary. But even if it were temporary, in the economic crisis in which Cape Town finds itself now, we can't afford to wait 2 years to feed people who are starving and who are in poverty and who need jobs and need economic recovery. That's not a delay which can be afforded. Your ladyship is faced with this massive, compelling reason to allow the development to go ahead and no arguments on the other side. It's a no-brainer, my lady, with respect.
I'm just considering now, should the development proceed, when will this review be heard?
When would the review be heard?
Do you have a date for the review?
There's no date.
No
There's
date.
no supplementary papers. Well, the Rule 53 record hasn't even been filed. So what your
The
ladyship...
record hasn't been filed.
No, as far as I know, the record hasn't been filed. So, and the volume of papers that have dealt with this give your ladyship an indication of what the review will entail. Just the case against the city, the applicants say that they haven't even formulated a case. They're going to look in the Rule 53 record, and they're going to file papers. And if an interdict is granted, they're going to have every incentive to drag the matter out, or at least the other way around, no incentive to expedite the matter. And whatever timeframes are put, in practical terms, those always get extended. The relief that's sought is an interdict pending the final determination of a review. So even if they failed in the High Court, that could go on appeal to the Supreme Court of Appeal and the Constitutional Court. One's looking at years, my lady.
So if the construction continues, how would that then impact on the review? Is it possible that the review could just become moot? I'm just asking.
Your ladyship asked that question yesterday.
Yes.
And it's a very important question, my lady. And your ladyship asked when the question was raised about the delay in instituting proceedings, and your ladyship said, well, what about the developer proceeding at its own risk?
Yes.
And that question is important, and it relates to the case in answer to your ladyship's question, which you've posed now. And that's, what are the consequences for the review? Well, let's assume that the review succeeds and that the court finds there was some reviewable irregularity. And then it comes to a question of remedy. What does the court do? And your ladyship has the references to the very wide discretion which a court has to grant just and equitable relief. It can order the demolition of buildings. It can order that the development be modified, that the heights be reduced. Or that investigation be done into all of those things. And there's a potential notional answer at that stage of the proceedings in relation to remedy for the developer to say, but the buildings are up. And the applicants have the answer which your ladyship asked yesterday. And the answer is, no, you can't say that because you proceeded against your own risk. They knew about the case, they knew about the pending review because it's been instituted, and they continued with construction. So they will not be able to say at the remedy stage in a review that this court is in any way obstructed in granting review, in setting aside the decisions and granting review relief. So the question about the developer proceeding in its own risk is a very strong reason for this court to refuse an interdict. It doesn't in any way, that the preceding construction does not, given that the developers are proceeding at their own risk, it does not provide an obstacle to obtaining whatever review relief the applicants may be entitled to.
So there will be other possibilities.
Sorry?
I say, so if this review should if the construction should proceed, there will be remedies available.
Sorry, there will be?
There will be remedies available. The
Yes.
city is saying there will be remedies available.
Yes.
In terms of, well, would also probably be costly, but toning down from 10 stories to 5 stories, I'm just making an example.
That's the developer's problem. It's a developer's problem because the developer is proceeding at its own risk. It understands that and it's going ahead. It won't be able to, it'll be constrained in saying to this court, well, the court should just, if notionally the applicants show that they've got a review ground, they would then be free to say this court must consider what to do without regard to the ongoing construction.
So in simple terms, what the city is saying is this court should not have any reason to intervene. In the review proceedings, the review court can
Yes.
decide whether there should be an intervention.
Absolutely. That's the appropriate remedy in this. We talk about alternative remedy.
Yeah.
That is what the applicants they've done. They've instituted the review. That's what that's the case that they brought, and that's the case they must proceed with.
But I would imagine this court, I don't even know whether it will be of assistance, but should this court decide to stop the construction, this court can then also regulate the further conduct of this matter by ordering that the review must then be heard on an expedited basis. This court would be empowered to do that.
Well, those kinds of orders are often, there's a practical reality. The court can say, well, you must file your record by next week and replying paper,
Yes.
supplementary papers by next month. And in my experience, milady, those timetables are always extended because there's just time is needed the record is going to be massive in this case. The applicants are going to need time to read through that, to formulate their supplementary papers. The respondents are going to have to consider those, to file answers. It would be very difficult for the parties to anticipate how long they would need to formulate a timetable because no one knows how long the record is. So notionally, yes, one could say let's have an expedited review, but in practice, it's going to take longer than what we expect. And given the relief being sought about for an interdict pending final determination, even an expedited review hearing by this court one would still need to add the time required by the appeal courts to consider the matter, and this court is not empowered to say that the appeal must be decided in 1 month or whatever. So one is dealing with an indeterminate time, and there's no way for the court to reduce that uncertainty. I think it's fairly safe to say that it's going to be an extended time. We're talking about years, at least more than a year, 18 months. And the evidence is that delay, the delay that's inevitable, should an interdict be granted, would be terminal to the development. So we're dealing with this suite of benefits for the development, heritage, environmental. I was dealing with the economic advantages, and your ladyship asked me, well, is the court meant to balance these out? And my submission is that there's no need for that because they both sit on the same side of the scale. One gets the benefits of development and the benefits of the economic advantages of development. So, and those economic advantages are very considerable and very important in this case. They dealt with in the affidavits.
Can I just pause for a moment? Maybe the applicant can address the court later on. Had this development not been on the table, the River Club would probably still have been a golf course?
It would have. That seems to be the case, my lady.
Is that the position?
Yes, as it has been for 27 years, and it would continue to not celebrate and commemorate and the heritage, and would continue to degrade the heritage. And the applicants wouldn't be coming to court to say that the golf course is offensive and something must be done. The status quo would have continued. So what we have is 27 years plus hundreds of years since colonialization of degradation and non-recognition of heritage. And here we have a project to say, no, let's fix that. And the applicants come to court and say, no, don't do that. And they don't say what else will happen. In fact, the evidence is that they're not going to do anything else. There is no other option. It's an application in which they only invite the court to do harm.
Well, we'll hear what the applicants have to say about the actual proposals and what is offensive about it.
Lady, we were speaking about the economic crisis
Yes.
that the evidence shows the city is facing because of COVID. And one of the things that economic crisis, how it affects people, particularly poor people, indigenous people, is the loss of jobs, the high rates of unemployment. And this development is a significant development. It's going to result in over 5,000 jobs. It's currently providing jobs to 5,000 people. And those are the direct employment opportunities. Indirect employment opportunities are 19,000 jobs. The court, we submit, can't disregard that and say that's not an important consideration. 19,000 jobs which will be lost in a context of a city facing an employment crisis. That crisis is referred to in the affidavits. It's not disputed. It's a employment crisis which is at historic levels. There's never been such a high unemployment rate. It's described as alarming and record levels. The rate for Cape Town is 30%. That's the formal employment rate. That excludes people who've given up looking for jobs. And it's resulted in profound poverty, or it's exacerbated a high level of poverty which already exists. And I'm not going to take your ladyship to the references. Your ladyship will be familiar with the economic problems and the crisis that the country and the city is facing. If I may refer to the also undisputed, the investment benefits of the development, the construction will provide an investment injection of 4.5 billion rand. And that's the direct investment of the construction work, and that will result in an increase in economic output for the city of 8.5 billion rand. Those are staggering figures, and if I may put them into context again to show how that relates to the construction activity in the city over the last period, and that's dealt with at the record at volume 5. Page 2094. And here's Mr. Kraeling's affidavit, in which he says that from 2018 to 2021, Cape Town had a 50% decline in the number of big investments. So even before COVID, there was a decline.
Sorry, where are you now? I'm not with you. You're on page?
Of the mind map.
Yes, where are you reading from?
I'm referring to the affidavit 2094.
Oh, sorry, I'm on 2014, 2094.
2094.
Oh, sorry. Yes, thank you. I'm with you.
So from 2018 to 2021, and one sees the graph there, the blue bars are the number of big investments. It's declined from 20 to 10, 50% decline. The red line shows the monetary value of that, and that's declined by 56%, from 2.3 billion to 1 billion. So there's this massive decline in the construction industry, and one compares that to the economic value of this project. Your ladyship will recall that the value is 4.5 billion. So if your ladyship imagines this decline from 2.5 to 1 billion, and this project alone will add 4.5 billion. It's a significant investment to the construction industry. And the construction industry is a major part of the economy, providing jobs and alleviating poverty. Transport, your ladyship is familiar with the road developments, Berkeley Road, there's going to be a bridge built. The value of that is 73 million. Residential, 31,000 square meters of high-quality residential accommodation, of which 20% will be affordable housing. This is one of the first developments in Cape Town in which the developer has said that integral to the residential component will be affordable housing. And it's the first approval, which I know of, in which the planning authorities have made that a condition of approval. So it's not just a promise, again, it's a legally enforceable condition. It must be provided. That's integrated affordable housing of 1 out of 5 square meters, 1 out of 5 units. All of that will be lost. That's the harm that will result from an interdict. And we, under that, the branch which said that an interdict will block these benefits, there's the evidence of the mayor which is undisputed. I'm not going to take your ladyship there, but because we've already debated this, it's the point that a delay in development can kill a development. And it's particularly acute. This development's been coming on for 6 years. When the first authorization, first notice of intention to develop was given, there have been a series of considerations by various authorities. There's the heritage considerations, environmental approval, planning approval, each with various challenges. There was a review case and an appeal in relation to the heritage matters. There was an appeal in relation to the environmental authorization. And the planning approval also had an appeal. Multiple considerations over a long period of time.
And the water issue as well.
And the water issue doesn't seem to be an issue because it was applied for and was granted, reversed, and the applicants have never said that there's a problem with the water license. It seemed to just be a tactic to prevent the development. But it was said in papers that it seemed to be an application without any merit, and they haven't suggested that. No, actually they've got good grounds. In fact, we know they've got no good grounds because if they did have, it would be a subject of this interdict proceeding. They don't even raise it. So it's really about heritage approvals, which are subsumed in the environmental approval, the environmental authorization and planning approval. So what happens with the development, explained in the affidavits, is as the development progresses, particularly a big one, it gathers momentum, which requires additional financing. It's very expensive getting to the stage when one implements. One doesn't simply hire the construction companies and start. There's a whole lot of professional work done with architects and engineers and setting up all the financial arrangements. And by the time it gets to planning approval, that's very far down the road, and there's massive holding costs. So an interdict at that stage then starts a wastage of costs, and that an interdict which then has the financial consequence. And the city has experience of this, which it said in the affidavits, is that an interdict can itself, even if the review fails, the interdict itself can kill the development. And we have the additional consequence here that the anchor tenant is not tolerant of any delay. So even a postponement to the development will do irreparable harm. The city has a particular concern about an interdict being granted, and there's been a question about, well, what is the city doing here? It's been suggested that the city is siding with the developer, and that's not true. That the city is is here giving effect to its constitutional duties, and it has duties under the Constitution, firstly, to promote sustainable development. There's a right under Section 24 to sustainable development, and the city has a duty under Section 7 of the Constitution, not only to respect that and to protect that right, but to promote it. That requires positive steps. And this project is an excellent example of sustainable development. It achieves development in a way that actually helps heritage and the environment. And the city also has duties under the Constitution to promote development, economic development. So those are in sections 1521 and 153A. The references are on the mind map. And so the city must promote development for the economy of the city, for jobs, and for the benefit of all the residents of Cape Town. And happily, there's no trade-off between those two considerations. So if one looks at the mind map, it's quite useful to look at this graphically, because that's the balance of convenience exercise that the leadership will be is considering. So there's one branch which says prejudice if the interdict is granted. And then there's the bottom graph on the map which says prejudice if the interdict is refused. And without reading the words on the map, your leadership will see all of the considerations which we've been discussing on prejudice if the interdict is granted. They're considerable, overwhelming, both in number of them and weight in them. And then the other side of the scale is what will happen if the interdict is refused. What's the prejudice? What's the harm? And there's not much there. But let's deal with what is there. The first thing to remind your ladyship of is the frustration that the court had on the first day of the hearing, asking the applicants, what do you want with the site? There was no answer, because the applicants aren't able to give a feasible alternative to the development as a way of protecting heritage. The throwaway, on-the-spot suggestion was some sort of expropriation. Well, that's not on the papers. What is on the papers is the city's answer to the question of an urban park, which has been mooted for a long time, and that's dealt with in volume 4, page 1456.
What's the page number?
1456.
Thank you.
The applicants contend, this is the mayor speaking, the applicants contend that this property should be converted to an urban park. However, the applicants offer no feasible route to achieving this. In 2003, the city accepted that an urban park was a development possibility for the site. However, over the past 18 years, such a development has proved to be a pipe dream. It is unfeasible because there are no funders for an urban park. There are no workable development plans. That evidence is undisputed. In reply, the applicants say that that just because an urban park is not feasible now doesn't mean it won't be feasible in the future. Well, that doesn't show that there's any road to feasibility. It's just a notional, well, maybe it'll be feasible at some point, but we've waited 18 years, and the city says it was part of this vision of having an urban park, and it's not going to happen. It's a pipe dream. The applicants do not explain how development will harm heritage. There's simply no evidence of that. The court is left with the conclusion that the evidence would not, that interdict would not protect heritage. And I've dealt with the developer proceeding at its own risk. So, looking at the practical consequences of an interdict, your ladyship, that scale analogy is going to weigh in, excuse the pun, in your ladyship's mind. On the one hand, what are the things that sit on the one side of the scale? What are the things that sit on the other side of the scale? And the image is a very disparate balance. There is no balance. There's nothing up here. It's just a pipe dream. And on this side, we've got the need to protect heritage, a way of protecting heritage, a way of advancing jobs, a way of providing economic recovery, all of which is going to be lost if an interdict is granted. So that provides an overwhelming reason to refuse an interdict, both if one looks at it from a balance of convenience and prima facie right, because the applicants on the outer test haven't shown that the development will irreparably harm heritage, will not harm the cultural rights. And even, in answer to your ladyship's question, even if it's not the test under outer, but even if what your ladyship is mindful of what consequences an interdict would have for the review grant. Given that the developers are proceeding at their own risk, there's no prejudice to the applicants in arguing for whatever remedial relief is appropriate. So that takes us to the second page of the mind map, which deals with the prima facie right. You should see there's two branches to this. The first one is just a reminder that the test under ALTA is that that's the only question of prima facie right is a question of whether there'll be irreparable harm to heritage, and we've dealt with that. The second branch to it is a branch which we submit is not relevant, but we deal with it simply because it's such a strong part of it's the entire case argued by the applicants, and that is the right to review. It's put in inverted commas because we submit it's insufficient, if it's either irrelevant or insufficient. So there are 3 points in relation to this. First is the law and pleadings. The second is the review case against the city. And then the third question is the issue of participation, which your ladyship is concerned about. So if I may start with the law, just to again set the legal framework for how the court will approach this. And may I refer to the bundle of authorities provided by the city, page 124.
Thank you.
And this is the Supreme Court of Appeal case in SR. It's a judgment of Judge Plaskett. And it's paragraph 60 to 61 of that case.
Yes, I see it here.
So in this case, the court was dealing with a case made out in reply by the applicants in that case. And Judge Plaskett says these challenges, so it's halfway through paragraph 60, these challenges were not raised in the founding affidavit, but only in the replying affidavit, with the result that the respondents had no opportunity to answer them. And this relates, and we'll carry on with the quote, but just to interject at this point, there's the question of what cases be made out against the city, and I'll take your ladyship through the affidavits and show that there was an attempt to make out a case in the founding affidavit which then collapsed, and then an attempt to make out a case in reply, and that is, the SR case says that's not permissible. And the reasoning for that is something which we'll deal with in the next paragraph of the judgment. But in relation to participation, which we'll come to, is that participation wasn't even made out in reply. So this is a considerable understatement of the position in this case. So even if it was made out in reply, that's impermissible, and that's what the court's dealing with here, where it says why you can't make out a case in reply. The court says, I have my doubts about the correctness of these arguments, but I don't intend to traverse the issues. The challenges fall for a more fundamental reason. In motion proceedings, applicants are required to make out their case in their founding affidavit and may not make out a case in reply. These challenges were not raised in the founding affidavit, but only in the replying affidavit, with the result that the respondents had no opportunities to answer them. And then the reasoning is important because it goes to this court's fundamental role in ensuring equity of proceedings, equity in the process of proceedings before it. And Judge Plaskett says this does not stem from an overly technical approach to pleading, but concerns fundamental fairness. It has been considered and applied by the Constitutional Court recently in the GKKITC case. The appellant, in that case, sought to introduce a new cause of action in reply. Cameron J. observed that the High Court had rightly rejected this evidence, as must we. He explained the reason for doing so as follows. This is not to stump GKKITC on technical points. It is to insist that a litigant should stick to the case it has set out in its challenge, and that it does not ambush its opponent in reply with a new case and new evidence entirely. So, the applicants may not make out a case in reply, and what they certainly may not do is rely on argument on a case that's neither made out in their founding papers and replying papers. We'll get to that with relation to participation. Firstly, the review case against the city in the papers and in oral argument. There are two features of the case against the city. The first is that it has been a shifting case, and the second is that the case has collapsed. The shifting nature of the case is set out in this table in the mind map. Does your ladyship have the mind map?
Sorry, where are you
May I
now?
refer your ladyship to the mind map?
Yeah, sorry, I was just consulting my notes. Yeah, I'm there.
There's a table there. Does your ladyship have that?
Yes.
So that sets out the case made out in the founding affidavit, the replying affidavit, and the oral argument. The references are in the record. I'm not going to take your ladyship there. This is a summary of the applicant's case. In the founding affidavit, there were three grounds for review of the city decision. The first was the pending decision to grade the site. That fell away because actually there was no pending decision. It was merely a request. It's not been persisted with. The second was a suggestion that the provisional protection order was still in operation. Well, the applicants now accept. In fact, in oral argument, my learned friend said the provisional protection order has lapsed. That's correct in law. It has lapsed. And the third attack was deviation from policy. In reply, the first two grounds fall away, and what we then have is a challenge that there's a flood risk and that wasn't properly considered, biodiversity challenge, and insufficient weight given to objections by the city's department. There was an appeal by one of the departments in the city, and the applicant said that the mayor should have given more weight to those considerations. Your ladyship will know that the weight given by a decision maker to a consideration is not a factor in a review, so that doesn't provide a review ground. And the flood risk and biodiversity are matters which are raised in reply, which it would be unfair for the city to consider. And that new material obviously falls out to be struck. It falls to be struck out, and there's an application to that effect. So what we left with, and may I just add that what happened after the founding papers is that the city filed answering papers which comprehensively dealt with the case made out against it, including a reference to the mayor's appeal decision. Your ladyship would have seen from that it's a decision which is 146 pages long, single line spacing, concisely written, detailing the consideration of all of the issues that the applicants raised, all of their concerns and objections, and a thorough engagement with all of those issues. The applicants brought their case against the city without having read the decision against which they were seeking to review. Their attack was a recycling of the complaints about the municipal planning decision, and there was a 1 or 2 lines in the founding affidavit saying the same problems apply to the mayor's decision. Well, that's wrong, because the mayor made a very different decision, a 146-page decision, a very substantial consideration, engagement with issues, a whole new set of conditions. The applicants didn't read that. And then once they did read it in the replying affidavit, they couldn't come up with a criticism of it. There's no review grounds based on a very, and correctly so, because it was a very thorough decision. So what one sees is oral argument in which the only complaint is, the only one that's actually mentioned is reliance, the reliance that was, there's a complaint that the mayor relied on the AFMAS report. And that's dealt with at, if I may ask the court to go to the note on oral argument at page 63. It's quite an extraordinary statement of the applicant's case against the city.
Somebody, I don't have that. Sorry, I can't find the note on oral argument. It's in the bundle, isn't it? Am I looking in the wrong place? Yeah, maybe it's this one. Yeah, but I found it. You're on page?
So may I refer to, we're going to come to that, but just may I refer first to the paragraph 4. On page 3, where there's a summary of the oral argument, and the applicants say that the applicant has established a prima facie right against the provincial authorities. And that's the only submission about having established a prima facie right. There's no submission that there's a prima facie right against the city. So that's a admission, indirect admission, that there is no prima facie case to review against the city. But one sees the treatment of the case against the planning decisions at page 63 of the note. So there's an extraordinary sentence that says, "It is obvious from the papers and heads of argument that the applicants are still in the process of refining their review grounds in respect to the municipal planning decisions." It's a rather quaint, shy way of saying there is no case. These matters will receive considerable attention in the affidavits to be filed in terms of Rule 53.4. So the criticism that one finds here, not even doesn't pretend to be a review ground, in the next paragraph is that the mayor's affidavit is that what they say is very extensive reliance on the AFMAS report. And then the submission 165, that the report is, that's the AFMAS report, is unconstitutional, unlawful, unreliable, based on racist archive material and racist conclusions, and is deeply flawed in further respects. And they say that too will form part of their affidavits coming in due course. So we need to just deal with the evidence on the AFMAS report and how the mayor dealt with it. And in that regard, may I refer to volume 2, page 577 of the record. This is the 146-page decision by the mayor. So on page 63 of that, there's, and I'm just going to, when I'm reading, I'm going to substitute the names for the first applicant. So it's referred to as the GTKC, sorry, it's the second applicant. So the mayor says the second applicant complains that the AFMAS report, that's the First Nations, RC First Nations report, attempts to write out of history the current Goya. Further, there's a reference to reliance at the end of that paragraph on colonialist and criminal Jan van Riebeck. And the mayor in the subparagraphs respond to that complaint that the AFMAS report attempts to write out of history the Gorinkai corner. In subparagraph 185.2, the mayor says that the second applicant has been fully able to participate in these proceedings, to put forward its own narrative, and it has done so. The city has considered the second applicant's submissions, so there's no question of its history being ignored or irrelevant or informants being excluded in the assessment of the development proposal. May I ask your ladyship to make a note next to that? And that is that in this report, and we did the exercise last night and checked, there are 40 references to the submissions of the second applicant in this report. That's how extensively the mayor engaged with what the second applicant said, and what its complaints and concerns were. Each one of them were catalogued, articulated in a way which was a fair reflection of the concerns and responded to, including this one, that the second applicant was by no means excluded. In the next paragraph, 186, the mayor says that the second applicant argues that the AFMAS report set out to diminish and smear the leadership of the Goring High Corner Council for purposes that we believe are motivated by the fact that the Goring High Corner unashamedly rejects the proposal. That's a quote from the second applicant's submissions. Rather than an inclusionary instrument, the second applicant contends that the AFMAS report, excludes and attempts to humiliate those who see things differently. So the way the mayor dealt with that is he said in sub 2, I acknowledge that the report contains allegations against certain persons that for purposes of the bylaw are unnecessary and irrelevant. I have accordingly disregarded those comments. The remarks about the second applicant do not detract from the other valuable contents that the AFMAS report presents. So the mayor says he didn't have regard to the offensive statements, the Jan van Riebeck diary statements, so they played no role in his decision-making. He said, yes, there's this part of the report that is offensive, that's not part of the decision-making process. There are other aspects in the AFMAS report which are relevant. Would it have been a reviewable irregularity for the mayor to say, there's a bad part of the report, therefore I'm going to ignore the entire report. What he did is the proper thing. He said, I'm going to ignore the bad part, and I'm going to consider the part that is relevant and material to the decision-making process. So that deals with the only complaint, only criticism, it's not a review ground, only criticism of the city's decisions. So there are no review grounds against the city. The debate in this case up to now about Section 38 is something that only has relevance to the decision made by the province. There's no duty on the city to do anything under Section 38 of the Heritage Act. And the applicants don't suggest that the city's decisions can in any way be impugned in respect of their complaints about Section 38. So that takes us to the consultation issue, my lady. And there are 2 points we make in relation to this. The first is that this issue is not pleaded. And we're going to go into detail to show you why it's not pleaded, because it's not just something that we raise as a technical point. We rely on the authority by the SCA and SL and by the Constitutional Court to the same effect that this is a matter which affects the fundamental fairness of the case before your ladyship. So under the branch of the mind map which says that the case is not pleaded, we refer to the affidavits. And the point we make is important. The affidavits do not claim exclusion. There is not one iota of evidence. There's no suggestion that anybody was excluded at any stage in any decision-making process. There's no allegation in the affidavits that a complaint about participation is a review ground.
Sorry, I just missed the last part. No complaint.
There's no
of?
complaint or there's no allegation or suggestion in the affidavits that there is a review ground relating to participation. And it's a point I was going to make earlier, but let me make it now, that in administrative law, a lack of participation is the first point that an applicant will raise. Your ladyship will know that it's the easiest thing to prove. I wasn't given a hearing, I didn't get notice, I was excluded, or something like that, is a complaint that can be easily established. And the law is very clear that where there's a duty to consult, failure to consult is a reviewable irregularity. It's a very easy basis for a review court to set aside the decision.
And there's no such allegation?
There's no such complaint. There's not even a suggestion that there might be a complaint in that regard. What we do know from the history of the litigation is that the applicants are searching everywhere in the process for something to attack the decisions. They've been involved in this process for 6 years at every step of the way. They have brought whatever complaints they could to the decision makers. They even attacked the water license when there was no reason to do so. They come to the court in their founding papers and they say, these are our review grounds. They get the answers, including more evidence in the annexures. In reply, they add more review grounds, impermissibly. But among those more review grounds in the reply, one doesn't find a complaint about lack of participation. If it had been a problem, it would be there. If the applicants had a problem with participation, they would have said so, obviously. What happened in this case is that the applicants presented their founding papers, the answer, the replying papers, no complaint about participation. They filed their heads of argument, no complaint about participation. The respondents we filed our heads of argument, we dealt with all the issues, and then the amicus comes along and says there's submissions which it wants to make on international law about participation, only on the assumption that there might be a problem with participation, a speculative set of submissions. There's no allegation by the amicus that there was a breach of participation. And so the amicus's submissions only have relevance if there was a failure to participate. And Province, in its answer to that, says, I think it was the developer as well, says the amicus can't plead a lack of participation, it can't plead a new cause of action. And so the applicants then grasp onto this point and say, well, in their oral argument, we're going to raise participation. Never raised before, presented in 101 pages on the day of the hearing, and, milady, what is that if not an ambush, which Judge Cameron says can't happen? So I'm not going to take your ladyship to the founding papers because let's rather go to the replying papers where there has been additional points raised, and it's in volume 7, milady. And I'm going to step into some of the allegations made against Province, not because I seek to argue their case, but because the participation complaint is made so nebulously and is not pleaded. The court doesn't know whether the complaint is directed at Province or City or both. So the suggestion is made that this somehow concerns Section 38, and that's, as I've said, is not a matter which concerns the City. But I need to deal with it just in case the court considers that participation is something the City needs to answer. So let's deal with what the applicants understood as relevant in relation to Section 38 and participation. And that's at page 2610. So here there's a quote of what Section 38.3 says, and and if I can ask your ladyship to turn over the page and then go back to page 2610, there are the various paragraphs A to G, and I'll ask your ladyship to note which are underlined, which are relevant ones to the reply. It's A and B. And what's significant about this is what's not underlined. The applicants don't say, look at E. They don't ask the court to place emphasis on the results of consultations with communities, because it's not relevant to the case. It's not relevant to their case. It's not relevant to this matter. In 39, they say the effect of A and B, 38.3A and B, is to stipulate that the heritage impact assessment must provide, at a minimum, a systematic inventory, including graphic representation. And then 40, they say, the purpose of this component of a heritage impact assessment, that's A and B, is to provide a complete objective picture of heritage resources that would be affected by the development proposals and how they are stated. It also serves to inform the inquiries contemplated in C, E, that's the results of consultation, F and G, viz. Assessment of the impacts of development proposals on heritage and relative social and economic benefits, possible alternatives, and proposed mitigations. So in 41, without an objective identification, appraisal, and mapping of heritage resources, and then it continues. The concern there is about the content of the HIA. That was their complaint. They said it didn't meet the information in the finding paper's requests, and then it morphs into alleged requirement. That's the complaint in the reply directed at Province, but they don't say that there was any problem with E. And at page 2615, there's a heading, the developer's failure to comply with the information requirements, Heritage Western Cape's information requirements. There's this allegation, which was the subject of a striking out application, that the developer failed to comply with the information requirements. They say it's obvious that the developer had failed to comply. And in disregarding the request in this interim comment to submit a supplementary report. So they alleged the failure to comply. And then they say they don't understand that the minister or Mr. Africhting to contend that the AFMAS report was a supplementary report. So they say that the objection here is a failure to provide a supplementary report, and then they go on to say in detail why the AFMAS report was not a supplementary report. And then paragraph 52, again subject to a strikeout application, but for this purpose it's useful to see all the criticisms of the AFMAS report. Here they say, and it goes on for quite a long a list of all the complaints about the AFMAS report. And just to highlight the point about this list is what's not here. There's no complaint that there was an exclusion. The complaints are 1, failure to undertake appraisal of heritage resources. 2, there's an aspiration, or it seeks primarily to ascertain the aspirations of the First Nations informants. 3, it does not record the identities of the participants or provide a record of the consultations. 4, impartiality. 5, methodology. And then 6 refers to another affidavit. And then 54 on page 2618 concludes saying that the developer has manifestly failed to comply with the HWC's information requirements. No complaint about participation. And then the summary on page 64, so on paragraph 64, the defects in the NEMA decisions. The facts and circumstances set out above demonstrate substantial and material defects in the heritage assessments and the Section 38.8 process. Patently, HWC's information requirements were not complied with. Accordingly, on the Minister's own construction of his powers, the jurisdictional fact necessary for the Minister to grant environmental authorization was absent. Our learned friend for the province has shown you that that's not true, but the point from the present purpose is that's the complaint in the reply is in relation to information requirements. And then 65, an allegation of usurpation of the exclusive jurisdiction of HWC. That complaint's fallen away. And then lastly, 66, reasonableness and rationality. Again, no complaint about participation. And then the next section, from 68, deals with the complaint against the city. And it's in paragraph 68, there are three grounds of review set out. And that is what I summarized in the table earlier on. And the complaint is that a proposal before the HWC to formally grade the river site was not considered. Number 2, provisional protection notice is in place. And
sorry, I'm not with you at the moment. Where are you reading from?
I'm reading from page 26, 22.
Thank you.
So this is the replying affidavit in which the applicants summarise their review grounds. And we dealt with the provincial review grounds, no complaint about participation there. And then from paragraph 68, the summary of the review grounds against the city. 3 review grounds. 1, the failure to consider that HWC, there's a proposal to formally grade the site. 68.2, provisional protection notice, and 68.3, policy. And again, it's what's not there that matters. There's no complaint about a lack of participation. And then in the mind map, there's a reference to the applicant's heads of argument. I'm not going to take your ladyship there. The paragraphs are there, paragraphs 92 to 122. That concerns the province. These are the heads of argument which were filed by the applicants. There's no suggestion that participation was a potential review ground or an issue. And then in relation to the city, paragraphs 123 to 138. So again, if the applicants were concerned about participation or thought it was an issue, they would have said so. It wasn't. wasn't an issue because there was adequate participation, more than adequate participation. On their understanding of the matter, there was adequate participation. So what we have in the oral argument is the ambush. And I'm going to take your ladyship to those submissions. There are two submissions made in the oral argument. The first is a claim that membership of the FNC is a precondition for participation. May I refer your ladyship to that note, page 40? Does your ladyship have page 40?
Yes, I do.
So this is the first of the complaints about participation, is that there's a reference to the statement in the AFMAS report where he says Mr. Arends has said that the position taken by the collective and invited the Goring High Corner to participate and join the collective, cautioning that the Goring High Corner that refusing to formally engage would constitute a voluntary extraction from the consultation process akin to self-imposed exile. So, and the submission is made. It is clear from this extract that it was a precondition for consultation that the Goring High Corner joined the First Nations collective. Lady, that's wrong. It's wrong, wrong, wrong. The AFMAS process was one element in a very long consultation process. And there's the point that your ladyship is alive to, and that's that the applicants, second applicant in particular, had the opportunity to participate in the AFMAS process, initially did participate and withdrew. But it's wrong to say that their non-participation either in the FNC or in the AFMAS process in any way excluded them from the consultation process, which was a process not before Mr. Arends. He wasn't the decision maker. He wasn't even the specialist in the environmental authorization. In fact, he wasn't even the EAP. The decision maker in the environmental process was the director and the minister. The decision makers in the planning process were the MPT and the mayor. If the second applicant excluded themselves from the FNC, that had nothing to do with their ability to participate in the decision-making process, which was a process involving the decision makers. And so the question your ladyship is confronted with, or would be relevant, again, only if your ladyship considers this matter something to be decided, and your ladyship would not get to this because it's not something raised on the papers. But if the court were to be concerned about this, the issue would be, well, was there exclusion of the second applicant in any of the decision-making processes? So let's see what the evidence is, not by the respondents, but by the second applicant themselves. And that in volume 2 is at page 742. So it actually starts at 741. So this is Mr. Jenkins speaking, in his affidavit, in which he says the Goran Haikona Khoi Indigenous Council has consistently opposed the proposed development and have taken a number of steps in an attempt to ensure that the heritage associated with the site is protected for current and future generations. These steps include, and then there is the 9 subparagraphs. So this is what the second applicant did in the process and was allowed to do and was involved in. 1, it supported the application for the provisional protection of the site by HWC. 2, participating in an appeals tribunal hearing concerning the validity of that protection order. 3, applying to HWC for the site to be graded as a provincial heritage site, grade 2, and making representations at the HWC hearings. 4, applying to SARA for the site to be graded as a national heritage site, grade 1. 5, submitting representations as an interested and affected party during the environmental impact assessment process. 6, submitting an appeal against the granting of an environmental authorization for the proposed development. 7, submitting objections in relation to the application for land use planning approvals for the proposed project. 8, submitting an appeal against the granting of the land use planning for the proposed project. And 9, making presentations to the Planning Appeals Advisory Panel. There are things which he doesn't mention. He made written submissions as well. But these are 9 aspects in which the second applicant participated in their own words. This is extensive participation. There's nothing following this that says, well, that wasn't enough. We didn't have an opportunity. We were excluded. This wasn't early enough. There's no complaint like that. There is no case that I know of and which the applicants can or will refer you to, either in South African law, foreign law, or international law, in which a court has successfully upheld a complaint about exclusion by a person who participated. It's not possible to reconcile those two concepts. I was excluded, but I participated. The fact that the second applicant did participate is the reason why they never complained about some sort of exclusion from the process. So that's as simple as one needs to consider this point. They participated fully. They had an opportunity to make whatever representations. They were represented by lawyers in the process, lady. In fact, Mr. Bishop's attorneys, the LRC, represented the second applicant in the city's process. I did my articles at the LRC. They are experts in representing and have a very long history. Their interests in a way which can be appreciated in complex legal processes. And so they had sophisticated, adequate expert representation. It was full and complete participation, early enough, fully compliant with whatever principles exist in national law and international law. So that disposes of the issue about membership of the FNC being some sort of precondition to participation. It wasn't. There was the opportunity to speak to the decision makers directly, which the second applicant and anyone else, the second applicant did, and anyone else either did or could have done. Your ladyship asked a question. Lady, the second submission that I wish to deal with that was made in the oral argument is on the question of exclusions, alleged exclusions. And it was both made in the written note and in oral submissions to your ladyship. First, the written note. Please would the court turn to page 43.
Where are we now?
This is the applicant's written note of oral argument.
Yes?
43. So at page 43, paragraph 107, our learned friends for the applicant say it is also important to note the extent of the First Nation groupings that were excluded. Does your ladyship have that?
Yes, I do. 107.
All right.
yes.
Now, what matters is that submission, the allegation that there were exclusions and that there is some sort of extent of exclusions. And then the next sentence, these are listed at paragraph 78 on pages 740 and 741 of volume 2 of the affidavit of Ms. Jenkins.
I see the
Can I
list
ask the
here.
court to hold that page
Yes.
open, 740? Does your ladyship have that?
I have the page here with the list, yes?
All right. Now look back at 107. This is the extent of First National groupings that were excluded, and the court has referred to page 740. And at page 740, it's paragraph 78.1, and it continues over the page, and there's a list of groupings.
Yes.
So in the written note, it said these are the exclusions, and then this was repeated in oral submissions. Your ladyship said, well, where is the evidence of exclusions? And my learned friend took your ladyship to page 740 and said, look at the list. Those are the exclusions. My lady, that's wrong. That is wrong. It's misleading. Look at the previous page, the one that you not referred to. It's what paragraph 78 is about. Paragraph 78 says the following. Despite the narrative disseminated by the FNC, the leaders of the vast majority of First Nations organizations have confirmed in their conversations with me that they remain strongly opposed to the proposed development.
Where are you reading from now?
I'm reading from the previous page. So
Page?
you were referred to page 740.
Yes,
And if one turns
so I must go back, right?
one page,
Yes.
paragraph 78, does your ladyship have that?
Yes, I do.
Despite the narrative disseminated by the FNC, the leaders of the vast majority of First Nations organizations have confirmed in their conversations with me that they remain strongly opposed to the development. If your ladyship can circle the word opposed. Of these traditional authorities and organizations, this is over the page, this is the part that your ladyship was
Yes.
referred to. Of these traditional authorities and organizations, the views and ethics engaged in this process as a violation of the SAN ethics, these include, and then there's the list. So what is it a list of? It's a list of the allegation is that these organizations oppose the development. They oppose the development. There is nothing suggesting that these groupings were excluded.
Is 78.3 not a different list?
Sorry, my lady.
Is 78.3 not a different list? I'm just checking than what is referred to in 781. 781 and 783, are we dealing with the same groups?
So there's the sub-paragraphs of 78 are lists of organizations.
Mm-hmm.
So the question is what do those lists represent? What's common to them? Why is the court being referred to this list? In oral argument, it was said that these are the organizations that were excluded. But that misrepresents the evidence. The evidence is that these are the organizations who oppose the development. Those are very different things. In fact, how does one oppose the development if one doesn't know about the development? If one knows about the development, one knows about all the opportunities to make representations. It proves the opposite of exclusion.
Is 78.1 and those mentioned in 78.3, are we dealing with the same groups? I'm just trying to establish that. I don't want to get confused now. In other words, those who participated and opposed, are we dealing with the same groups in 78.3? Those mentioned in 78.1? Is it the same group as 78.3?
I haven't done the analysis,
Yeah.
milady.
It doesn't
wasn't-
appear to be the same. That's why I'm asking.
Yeah, I can't answer your ladyship's question off the bat.
Sorry, 78 refers to, it says of these traditional authorities and organizations. Can you just clarify what does the city say with regard to the exclusion of those mentioned in 78.3?
What does 78, what does the city say about?
The exclusion of those mentioned under 78.3, is that not correct?
No one was excluded,
I
milady.
see.
Nobody was excluded. Everyone was invited to participate, and they either did or had the opportunity to do so. And some supported the development, and some organizations opposed the development. The allegation made by Mr. Jenkins is that these are the organizations that opposed the development. He is not saying these people were excluded.
Oh, I see.
Does your ladyship have
I
the...
see.
He says they're opposed.
Yeah.
He doesn't deal with participation because it wasn't an issue
I
that the applicants brought to court. He's saying, look, I'm not alone in objecting to
Yeah.
development. There are other people who also object.
I see.
There's a long list of people who object.
By implication, they are actually included in the
They
in the
must be. That's the only
participation
inference
process.
one can draw from that. Is
They
that
were included.
They were participating. Indeed. It's certainly no basis for the submission by my learned friend that these people were excluded. That's simply a misrepresentation of the evidence. In fact, there is not one allegation of exclusion in the affidavits. So your ladyship can put that question on the facts out of the court's concern about the processes involved.
So this would then encompass those opposed to the project under
Allegedly, my lady,
78.
yes. Yeah. I don't have a comment on whether they in fact opposed
Because
or not.
it's a large
hearsay
group, that's why I'm
allegation.
asking.
Sorry?
It's a large group, that's why I'm asking.
Apparently, my lady, I don't have
Yeah.
submissions on that. I can't say whether these groups overlap, how many they comprise. There's an allegation by the FNC that they represent the majority of Khoi and San groups. The city's position in relation to these competing claims for representativity is that the city doesn't need to resolve that, doesn't need to say the people and the supporters outweigh the objectors or the other way around. The city's approach would just say, I'm going to listen to all the submissions. It's not about saying, well, the city can't and the province can't exercise its statutory powers by holding a referendum on its decisions which it needs to make and then saying, well, the public must decide. It's a decision which must be taken in terms of the relevant considerations in the statute, and the views of the communities are important. But if there's extensive opposition for good reasons, those reasons must be considered. And as I've said, the second applicant's concerns were referred to 40 times in the city's reasons. And what Mr. Jenkins is saying in 78 is that his views also represent the views of all of these other people. So all of those views, whether they're a large number or however many people they are, were all properly considered. And that's the relevance of that for this court in considering potential review
He
ground.
said he had discussions with him. Let me see the words that he used. They confirmed in conversations with me.
That's Mr. Jenkins
Yes.
saying that he spoke to these groups.
Yeah, these groups, yeah.
So that's hearsay evidence because those groups don't come along and say we're co-applicants or we confirm that.
Yeah, I think the applicant can clarify that in reply. Yes.
Well, the point that you can now ask your court to direct this question to the applicants in reply is where in the papers do they allege that anybody was excluded? It's not 78. That doesn't say that anyone was excluded.
Yeah.
Where else is there an allegation of exclusion?
Well, it appears that those mentioned in 78 were aware of the project
Indeed.
because they discussed it, because during their conversations with him, he then established
Yes.
that they opposed the project.
Yes.
So, by implication, they were aware of it,
Yes.
they were consulted, and they expressed their view.
Yes. And they expressed their view to Mr. Jenkins, who
Yes.
represents the second applicant. And Mr. Jenkins has told us in his paragraph 80 how extensively he was involved. And any one of these other groups, either represented by Mr. Jenkins and the second applicant, or themselves could have also been extensively involved. The complaint made in the oral argument, which is impermissible, but the complaint is a complaint about lack of participation. It's not that there were lots of people opposed to it. That the applicants obviously accept is not a basis for review. The complaint here is exclusion, and there's no evidence for that, so the court doesn't need to concern itself with.
The applicant said here in paragraph 79 that he will obtain supporting affidavits in the review proceedings. He will. That's what he says in 79.
Yes, and that would be support
For
of
the
their
review.
opposition to
Yeah.
the development, not support of any complaint about participation. That's the only evidence here. Is there's opposition, and we're going to get support in the form of affidavits. Milady, the last point, so this leg of the argument in relation to consultation is that the case wasn't pleaded, the claims in the oral argument are unfounded and not supported by the evidence. In fact, they're contradicted by the evidence. And so there's no case before this court of any problem with participation. The city did provide heads in response to the amicus, and the city focused on if I may refer your ladyship to those heads. So on page 12 of those heads is paragraph 27.
Are we dealing with the city's heads now?
It's the city's heads,
Oh,
or the
yes.
second set of heads dealing with the amicus.
Yes. Yes, page 12.
So on page, does the leadership have page
I'm on page 12 of the citizen.
12? Yes. So
24.2, yes?
So and I'm not going to take your ladyship through this, but
Yes.
what we do at paragraph 27, which goes over a number of pages and various subparagraphs, is in response to the hypothetical contention by the amicus that if there was no participation, then various principles in international law might apply, is the city sought to just say, well, it's not an issue because on the facts there was such extensive consultation that the review court would never get to a question of saying, how do we apply international law? So what the city did is did an exercise which it was difficult to do because it wasn't an issue of 80 of Mr. Jenkins where he said they participated in all these various respects. And what your ladyship can match that up with this more extensive list of participation opportunities.
Where are you reading from now?
I'm reading I'm referring to paragraph 27 of the city's second heads in response to the amicus, where the city says that there was adequate and effective public participation in the decision-making process.
Yes. I'll just see if I can just find it in the bundle copy. I did put it here. I'll just keep that. Is it there? Oh, okay. Yeah, sure. Fine. Yes? Page? You're on page?
I'm on page 12 of
12,
the
yes.
heads, second heads. Does your ladyship have paragraph 27?
That's right.
So paragraph 27 goes over a number of pages. It has
I see,
subparagraphs. There are 21 subparagraphs. I'm not going to take the court through them. They have references in the footnotes to the record showing where the evidence is, and it's all uncontested evidence about the various consultation and participation steps that we have available on the papers, despite the fact that participation wasn't even raised as an issue. One can still scrabble through affidavits, and my junior did the tedious exercise of trying to find all of this evidence, despite the fact that it wasn't actually pleaded. And one sees all of these opportunities, and it's more succinctly summarized by Mr. Jenkins, where he said this is how he participated, or his organization. And if one goes to paragraph, on page 17, subparagraph 13, there's a reference to the AFMAS report.
Yes, I see.
And that's the first, so what happened is there was an initial participation process, statutory participation process. Heritage Western Cape wasn't satisfied with the adequacy of that and said to the developer, engage further. Mr. Arendse was contracted to have a more participative, engaging participation process, and that then fed back into the formal HRA process, which then fed into the NEMA review and was considered by the city. So it was one component of a statutory process of participation, which involved many more things other than just the AFMAS report. And the paragraph 20, just going towards the end, there was a final BAR, that's the report in the environmental process, and there were multiple phases of public comment, 494 comments from the general public. The second applicant and the first applicant were both among the commenters on the BAR. Mr. Jenkins specifically mentions that in his list in paragraph 80. So that was participation. And then in relation to the planning decisions, the last paragraph, and this is, we deal in one of the paragraphs, so the last paragraph, sub 21, is one paragraph in which we deal with all of the participation by the city, but that was 4 opportunities. There was written submissions to the MPT, oral submissions to the MPT, written submissions on appeal, and oral submissions on appeal. And so those were multiple opportunities which extended beyond the requirements of the statute. So that list then factually disposes of any complaint of non-participation or lack of participation. And as your ladyship has observed, there will be still further opportunities in relation to the specific commemoration features in condition 21 of the city's conditions. So even though the decision's been made, the consultation will still continue. Lady, that concludes the submissions on participation and on the notion of the question of whether there's a right to review and the prima facie right and the requisites for an interdict. So for all of those reasons, we submit that the court must refuse an interdict. The last thing I need to deal with is costs, my lady. So it's the last leg of the mind map. And your ladyship will be concerned with how to apply BioWatch in this matter. That's the case on which the applicants say they should not be asked to pay the costs of the respondents, or at least the state respondents, should they lose the interdict application. And so one needs to look at the authorities on how to apply BioWatch. So there's a constitutional court case in Harilal, 2018, the citations in the mind map. And the court deals with the exceptions to the BioWatch principle. So the general rule is that a losing private litigant does not pay the state's costs. But there are exceptions. And among the exceptions is if the litigation is instituted without sufficient ground or without probable cause. That's the test. Litigation instituted without sufficient ground or without probable cause. And the Constitutional Court relied on its previous decision in Lawyers for Human Rights, which is the citations given. So where someone comes along and waives the Constitution and says this is constitutional litigation, but in fact there's no substance to their case, then they must pay the costs. BioWatch doesn't protect them. And that principle has been applied by the SCA in the Burkhardt matter, a planning matter as well. Your ladyship will be familiar with that. It's been dealt with in a number of cases which your ladyship has considered. Paragraph 86 of that case, the Supreme Court of Appeal, a unanimous decision, says, as has been stated by this court in National Home Builders Council, the mere labeling of litigation as constitutional is insufficient. For the BioWatch principle to apply, the case should raise genuine, substantive constitutional considerations. The rule does not mean risk-free asserted constitutional litigation. That case involved the Burkhardt community saying that the building erected next to so Burkhardt is in fact a protected heritage site. I think it might be a national heritage site. So it has heritage protection, formal heritage protection under the law, unlike the River Club site. And it was a very controversial development. The city's heritage department opposed it. Heritage Western Cape opposed it on heritage grounds. The applicants brought a case against the planning approval on heritage grounds. They said our constitutional right to culture and heritage is violated by this building. The court looked at the case and dismissed it and said, no, there's no substance to your case. The applicants, the objectors appealed to the Supreme Court of Appeal. The Supreme Court of Appeal said there's no substance. And on the question of costs, ordered the objectors to pay the costs because there was no substance to their case. So in this matter, in the Burkhardt matter, if one reads the judgment, there were a whole lot of arguments about heritage, about what effect the building would have on heritage, would it be imposing, would it kind of destroy the sense of place of Burkhardt. There was something to argue about. Here, there's nothing to argue about in relation to the effect of the development on heritage because the unanimous evidence, the consistent evidence is that the development will only help heritage. And on the review grounds against the city, the case has manifestly collapsed. There is simply no case. The applicants don't even suggest that the one thing that they raise, the utmost report, is in any way a review ground. So this is quintessentially an exception to BioWatch. The applicants initiated and they persisted, even after the answering papers were filed, with the interdict in respect to the city's decision without sufficient ground and without probable cause. And for that reason, we say that they must pay the costs of the city, including to council. Those are the city submissions, milady.
Thank you very much. After 12, we can proceed, I would imagine.
We may proceed. Lady. My lady, I appear for the 8th respondent in this matter. The 8th respondent has been left out of these proceedings, while full knowing that the 8th respondent has a substantial material interest in the outcome of this matter. Because the 8th respondent was part and parcel of the entire consultation process. Now, my lady would have, if the 8th respondent didn't made an application to be joined in this matter, my lady would have ordered because they were part and parcel of the process and because they had an interest in the outcome of this matter. Why they were not cited, we will submit. Probably it's not an omission by mistake. But it was intentionally done because, and my lady, and I'll stick it up just now, my lady, why we made that submission. Because it goes to the heart of the issue how this second applicant have dealt with the consultation process to date. My lady, the 8th respondent is in front of this court as a collective of different houses, different councils. The councils of the Koronekwa, the council of the Horakwakwa, and excuse me for the pronunciation thereof, Kohakwakwa, the Corona, the Griqua royal houses, the Sand royal houses, and the likes. The second applicant stands here on his own. It's one council. And the 8th respondent has been relegated just to a small group of people. Not so. They represent councils. And in front of this court, in the second applicant, it's one council. My lady, I intended to address my lady and make submissions on a number of issues. One of them was whether the applicants were entitled to an interim order. That has been well traversed. I will not even deal with it. The second issue that was extremely well covered as well, my lady, was the issue on participation. And I'll probably just deal with it by referring my lady to one or two additional points in this regard.
Can you clarify is it paragraph 78, if my memory serves me correctly? Those who opposed the long list, or maybe I should refer to it as the long list of various houses, did they participate or did they not participate? Did they just withdraw from the process, not participate, and just express their view that we're opposing? Or in which manner did they participate?
The councils that I've just listed were represented in the First Nation collective.
I need you to elaborate more. I need you to elaborate more. What would the total council component be? Say, and out of the total component of councils, how many participated actively in the process?
Yeah. And I will deal with it, my lady. I'm just giving a brief outline at this stage, just on the issues that I want to deal with. And I want to make the distinction between the participation, which is by and large a process issue, and consultation.
Yes.
And I will deal with that as well. And then I'll try to deal with the issue that my lady has raised all the time, is the issue of risk. What will happen if the project is stopped or not? And I'll try to deal with that as well. Now, my lady, I want to take my lady, that has already been done, to 741, page 741 of Mr. Jenkins's supporting affidavit.
Where are we, in volume 7?
It's page 741.
Oh, no, we're not.
And volume 2.
Oh, volume 2.
So it starts at 741, paragraph 80, which was just well echoed now by the city, and that demonstrates the extent of the participation by the second applicant.
Oh, we're back here now. Yes.
Yeah.
But I'm not interested in the second applicant at all. I'm interested in other councils and other groups.
And I will deal with it, my lady. To the extent that this participation, my lady, was even well received by Heritage Western Cape. And they, Heritage Western Cape, at Annexure LL10, which is at page 150 of volume 1, even under the E, which is under 38.3E, which deals with the result of consultation, says the following. It says, Heritage Western Cape acknowledges that in terms of the provisions of the PAJA, insofar as a formal notice and commenting procedure is concerned, that the report complies with this section. So even in terms of Paja, according to Heritage Western Cape. That's compliant.
Sorry, I just missed you. Where are you now reading from?
I'm reading at page 150.
150. But I'm at 142. So you saying 150. Where are you now?
At
S?
E,
Oh, E.
Yeah.
Thank you.
which deals with the result of consultation.
Yes.
Comments and says that even in terms of the process, that notices and the participation, there's compliance in terms of Paja. So, they then further on there, the third paragraph under E says the following: as previously noted, the DT and PW itself has entered into a stakeholder engagement with First Nation communities, as it has recognized that the baseline study has first tabled at the ICAM on 12 April 2017 was deficient in this regard, and it now seeks to rectify this. And we know that that has happened. So in terms of the accessibility to the process, the transparency to the process, participation, effective participation did take place.
What, you see the last sentence under E, what does that mean? I don't understand that. Under E, the last line.
That last line, my lady, was probably in the context of the entire Trop site development relative to the River Club site development at the end. And
Is that a negative statement that HWC is making here? Is it a negative statement?
it is. It is, my lady, but to what extent does it detract from the fact that there was participation? It doesn't. So, I want to outrightly as well, my lady, emphasize and echo the submissions that were made by my learned colleagues as well, that there was no precondition at all set for the second applicant at all to be part of the First Nation collective. In the beginning of the process, my lady, they were part of the First Nation collective. They then opted out of this process, voluntarily opted out of the process to be part of the collective. May I make the further submission, my lady? They are more than welcome to be also part of the process tomorrow, because they're not excluded from the process.
So they participated up to a certain point and thereafter withdrew.
They participated throughout the process.
Oh, I see.
But they dissociated themselves with the First Nation collective because the First Nation collective had decided to support the process and to support the development. And they were against. My lady, let me then deal with a question of consultation. Now, and if I see the issues that my lady is grappling with, under consultation is the issue whether that consultation was real consultation, meaningful consultation, that result in a tangible outcome, and not just a pretense of a consultation. My lady, our submissions is, indeed, it was a meaningful consultation. And I will demonstrate, my lady, as to why we say it was a meaningful consultation. So not only were the First Nations Collective given an opportunity for their voices to be heard, but they had an opportunity to negotiate a settlement, negotiate something tangible out of this process. One of them is the right to return to the land, which is a very important aspect.
Which would encompass what? How do they return?
And that right of return to the land, my lady, is to be physically present on the land. And I will deal with it now by taking my lady through as to the benefits that will be manifested by returning to the land. But what I want to demonstrate to my lady is that even if we look at the Hart and the Townsend HIA report at page 183, where the second applicant made certain recommendations.
Which volume would that be? Volume?
It's volume 1.
1. Yes?
And it starts off, my lady, and says that the Boronai Kona have made a number of
You're on
recommendations.
page
At 183, my lady.
183, thank you.
Where it says that Boronai Kona have made a number of recommendations, which we include here as an articulation of the view of the site as heritage. Then it lists the number of recommendations that has been made. And if we go then on to page 184 as well, my lady, and I will then also show my lady that these recommendations were then also incorporated in the design of the project, as just recently articulated by my learned friend for the city. So,
It's a long list of recommendations. Were all of them accepted? I see there's reference to excavations.
not all of them were accepted,
No.
my lady, but especially the ones that specifically related to the heritage elements were incorporated. My lady, then further on, at page 229,
You're on page
229,
229.
and therein, once again, my lady, is an indication that those contributions have been considered, those recommendations have been taken into consideration.
So there is no suggestion that the property should be expropriated.
Not at all, as one of the recommendations. Now, the meaningfulness of the contribution that was made is recognized even by the second applicant in his founding affidavit. And if we go back to volume 2 at 738. At 738, volume 2, and one of the tangible aspects is also recognized, my lady, at 73.6, where it says, the developer has also entered into a social compact agreement with the First Nations collective, in which the developer commits to ensuring that members of the First Nations collective benefit from the procurement processes during the construction of the development. Then he goes further and he says, the social compact with the First Nation will also involve, then he lists those recommendations that he also previously made, which is now part and parcel of the process. Now, these are entailed in a binding agreement, which has now been signed between the First Nation collective and the developer. And these benefits are not just, they are benefits where the First Nation can find an enclave into the future. So it's not just during the construction process, it's not only during the completion of, but it will continue in time memorial. So that's the strength to which the First Nation collective have negotiated the settlement. And that's the extent of the depth and the intense nature of the consultation, the meaningfulness of the consultation that have taken place. So it has a concrete outcome.
If you can just pause again with regard to the consultation process. What is the answer to my question? How many councils are there in total, and how many councils were against the project, and how many councils were opposed? Do we have the numbers or not?
My lady, the councils could be found at volume 6, starting at the founding affidavit of, starting at page 2527.
I don't want to just talk about the First Nations collective anymore. I'm interested in individual councils, based on what I saw in paragraph 78 that was referred to earlier. So, yeah, here's 7.4, I see here.
Yeah. So my lady, firstly, what's represented here is 6 councils already. And as I said in the beginning, my lady, in front of this court is only one council.
The FNC consists of 6 councils.
Indeed.
Excluding the second.
Excluding the second, my lady. So, then, my lady, if one goes then further on that founding affidavit, answering affidavit, my lady, at starting at page at 26, from page 25 to page 26, there an indication is given that the status of some of the organizations that the second applicant is referring to. And if my ladies see there,
You are in volume?
it's volume 6.
Right. Page?
Page 2551.
Two, 551. 4, 3, 2, 1. Yes? Is there an answer to my question, and must I tell you why I'm asking the question? Mr. Arendse completed the first report, and thereafter he was mandated to complete the second report with regard to intangible heritage value of the property. So you're dealing with the same person who consulted them initially. And the first report already expressed a view of the First Nations collective. So the second report was not concerned with whether there was opposition or what the position was. In other words, I think putting it in a negative manner, I would say that the developer knew of the contents of Mr. Arendse's first report, so the developer could then assess from that report that there appears to be consensus by a certain group within the First Nation groupings. Then Mr. Arendse was then mandated to complete the second report, so the court does not have the advantage of a report emanating from someone else other than Mr. Arendse. So the court is not 100% comfortable to just rely on report, on that specific report. It's been criticized by the applicants, and the court is trying to find objective evidence of the participation process and accuracy in respect of who was included and who not. Perhaps the onus is on the applicant to do that because they raised the issue. They're not happy with Mr. Arendse's report. But it serves no purpose just to tell the court that the First Nations Collective agreed to the proposals. The First Nation Collective comprises 6 councils and they entered into a social compact with the developer. That is not sufficient. I need to know who did not participate in this process, with specific reference to paragraph 7.3 and further that the court was referred to earlier.
My lady, probably the manner in which to answer that question is to say that even the ones that participated in the process that have objected to the development, those views have been considered. The ones that were not there, my lady.
But then you need to allay the court's concerns, the court's fears. I need to know why is it that the court is not provided with the numbers now? I need to know, perhaps the court should ask for a note on that. Who was included, who was not included, who agreed to the... I don't also want to complicate the issue because for me it's a simple question. How many councils are there in total that have an interest in this matter? How many participated? How many were excluded? And who voluntarily were excluded themselves? But the second respondent is a party who actually participated, so I'm not really that much interested in the second respondent's position at this stage. I'm interested in the position of groupings within the First Nations who were possibly excluded. That is all the court is interested in. So I don't think it's a complicated question, but the court is struggling to find an answer to the question.
My lady, in terms, if my lady will be so pleased, we'll try them to submit a note in
Yes,
that regard.
yes.
But as I said, the real question for these purposes, in this application, for an interdict, will not assist the court to a great extent.
But isn't
the
it
real
important,
question-
sorry, for purposes of public participation, the court must be alive to the fact that there exists X amount of councils, and this is the amount of councils who participated, and the remaining councils then arrived at a decision and then entered into the social compact with the developer.
Or, my lady, it is whether the process was well known, publicized, invited people to comment, and people had the choice and option whether they want to participate in the process or not. And
Well,
the
that's
ones
a good
that,
point. That's a good point you're raising.
Yeah.
So you have an idea what the court is looking for. Yes?
and we might not even be in a position to accurately give the court that information.
We
But,
are
that's-
dealing with a vulnerable group in society, indigenous groupings. So we must just be careful when we exclude vulnerable groups, and that is what the court is trying to
Indeed,
establish.
indeed, so my lady, and hence I went back to Heritage Western Cape's
Yes.
comment
Yes.
in their comments on the HIA, where they recognize that in terms of the process for participation, that has been complied with. And that's a material element, my lady. So,
And the court should then be comforted by the view of the HWC because for all intents and purposes they are not here and they raised some concerns that they had. So they are not necessarily in favor of the contract, they're a neutral party. Or, yeah, I would say they did not participate, did not institute any action. So you are saying that the court should be satisfied if HWC says
that they are satisfied.
yeah,
Indeed, Somali.
Yes.
And their only concern was a division. But the division between the First Nation collective or the Khoi groupings themselves, my lady, those that were opposing the development's views were taken into consideration. So they were not discarded at all through the process. My lady,
can you
No.
just pause one moment? So are you saying that had there been any groupings who were dissatisfied, that HWC would have alerted the parties?
they would have indicated that. They would have indicated that indeed. And said there's a group of people here that were not part and parcel of the process. They
Or
did
a
not know-
majority grouping?
My lady,
I must express the court's concern. I'm trying to assist you by asking you decisive questions. Had there been a majority group within the First Nations that was excluded, HWC would have recorded it.
indeed. Indeed. So, my lady then asked the issue of risk. What will happen if this project does not continue? The only way, my lady, I can put it is in the title of a book, A Dream Deferred. It will be a dream deferred for people sitting here in the gallery. 70-year-old people, 80-year-old people of the Khoi saint descendants that want to have the right of return to the land. It will mean the lost opportunities that was just articulated, even lost opportunities in the social compact agreement which guarantees them a right in perpetuity. It guarantees them a right of return to the land. That will be the risk.
Would that be on the basis that they participate in commercial enterprises within the development? If you use the word return to the land, you are referring to participation in the commercial enterprises.
Indeed so, including the heritage aspect as well. So it's on both counts, my lady.
And what do we currently have there? No participation, no provision made for the protection and preservation, and to educate the general public about
Indeed so, my lady.
the First Nation.
Indeed so, my lady. Those opportunities will be totally eroded.
I'd like to ask the eighth respondent, what is the position with regard to this golf course that was there? If this project didn't happen, what would would the status quo just have remained? Or is this a situation where a different type of development would have been more suitable?
My lady, in my head, we alluded to the binary option, or to what is internationally also recognized as options where a site like that could either be preserved
Yes?
or restored. Now, there are specific instruments in terms of the National Heritage Act, specific sections, where you deal with preservation of a building, the restorations of buildings. What the eighth respondent is advocating is also a consideration of reconstruction.
Why did the applicant refer to throwing concrete in the Lisbik River? Because my initial understanding was that the river was going to be rehabilitated. So when you see the word rehabilitated, you attach a positive connotation to what is anticipated. But the applicants appear to attach a negative connotation to that. So I'd like to know what is the eighth respondent's view on the statement that concrete is going to be thrown into the river. We know the position with regard to the land that was infilled, the history, etc. Can the eighth respondent just allay the court's fears with regard to what is going to happen to the Lisbek River? And probably Black River, the confluence of the rivers, which is a central feature in the debate.
My lady, I think the respondent for the city has in some way answered that question. And that
I'm trying to establish whether the eighth respondent is satisfied with what is anticipated, what is going to happen to the river, how it's going to be rehabilitated, the manner in which it's going to be done. Is the eighth respondent satisfied with that?
And hence, the eighth respondent is well aware and well alive of that, my lady. And for those reasons, they have assented to that. My lady, what I want, my lady, and that's the other question my lady is probably grappling with, and that is whether the issue of intangible heritage and will be preserved and be expressed on that premises. And my lady, I'm only this morning I looked at a practice note from ECOMOS, and that deals at least, and it gives at least some indication of how a person deals and how a person appreciates the relationship.
Sorry, I just missed you. Are you referring to one of the UN instruments?
It's specifically...
Yes, so I know what you're talking about. Yes, you may proceed.
Indeed so. Where it deals with the appreciation of the relationship between place and cultural practices. And may I read it? It says, not all cultural practices that occur at a place will have a significant connection to that place. And nor will every place be associated with cultural practices. So some cultural practices may not require a particular place, and some may simply occur in a convenient location for the community or group engaged in that practice. It's that out of that perspective, my lady.
But we do have the observatory there. We do have the reference to the stars with regard to the traditions of the indigenous First Nation groups.
And for those reasons, my lady, in terms of the design specification, that has been taken into consideration. And hence the views to the Signal Hill and the views to some of the parts of the mountain have been have been part of the design specification in order to make a provision for that. So, my lady, the expectations that for the First Nation collective, as negotiated, has been met, and therefore there was support for this project, my lady. My lady, as I said, that the question of whether this application must fail or succeed, we make the same submissions as the rest of my learned friends, including my lady, that we believe that this application must fail.
The eighth respondent says that the First Nations were adequately represented, they were adequately consulted with, and they were provided adequate opportunity to participate in the public participation process. Is that what the eighth respondent says?
Indeed so, my lady. And for those reasons, this application must fail with cost, my lady. As a court, please.
What does the eighth respondent don't rush to, you're not done yet. I'm just checking something. What does the eighth respondent say? Are the applicants not here because they are concerned about the preservation of the heritage, etc.? Would that not trigger constitutional issues in terms of costs?
My lady, I've addressed that in my heads of arguments as well, and I've addressed the submission in my heads of arguments.
I'm looking now, yes, I'm trying to find that.
I've addressed that at page 27 and 28 in my heads of arguments as well, my lady. And I refer to the same cases, how
Yes. Well, we're dealing with the First Nations collective who has perhaps more understanding than any of us in terms of the issues that were at stake in this matter, or that the issues which are currently at stake as we speak. It's going on review, etc., etc. So the eighth respondent will appreciate what this matter is about. What are you saying on page 27 with regard to costs?
my ladies asked me a question on cost.
Yes.
And I said on page 27 and 28, I deal with the issue of cost. I deal with the two matters, the Boer Cup Civic and Ratepayers Association matter, and I deal with a BioWatch trust case as well, my lady. And I deal with it from a perspective that in this application for an interdict, no real constitutional rights issues have been raised.
Isn't heritage automatically, doesn't it become a constitutional issue? The issue of heritage, preservation of heritage?
Indeed so, my lady, but that issue, my lady, is an issue for the review application. For the interdict, my lady, it is the question of whether the applicants will sustain harm. And that has not been well argued by the applicant in this matter.
Well, the
case has not been put
Sorry?
forward.
Sorry, I interjected, yes? You say the applicant did not make out a case.
No,
for
they
this.
did not make out a case.
I note that in your heads. Will the eighth respondent please provide the court with a note with regard to the total amount of counsels involved, or, with regard to the total amount of counsels that exists within the First Nations groups, and how many participated in this process, and the extent of their participation.
I will indeed do so,
Thank you very much.
as a course practice.
Are we going to adjourn now for lunch and then come back for the applicant? Is that our program for the day? Or does would the applicant like to proceed now? I'm at the parties can decide. Let me see. Oh, it's 1 o'clock. Perhaps we should take a short adjournment, just in case anyone needs a comfort break. Shall we come back at 2 or 1:45? 2 o'clock. Court will then adjourn until 2 o'clock. Thank you very much.
further instruction on the question that my lady asked me. And if my lady further directs that I must do something in addition, then I will do so. But just for clarity's sake, my lady, the instructions is the following. There are 5 houses. One of them is a Cape Koi.
Can you put that in a note for me? I'll listen to you today and you will then put that in a note for me. Yes?
I will do so, my lady.
I'm not going to write down the names of all the houses now, but there are 5 houses. That is what I'm interested in, yes? You can, in total, 5 houses.
There's the Cape Koi.
Yeah.
There's a Nama.
Yes?
There's a Sen.
Yeah?
There's a Corona.
Yeah?
And then there's a Griqua.
Yes?
Now, under the Cape Koi,
Yes?
my lady, and probably to do justice to the representation of the Cape Koi as a whole, is to refer my lady back to what I've referred my lady to in volume 6. And under the Cape Koi is a Horaniqua, the Koroqua, the Kohoqua, the Corona, the Sand Royal House of Nantes and Sand Structures under the leadership of Petrus, Fowboy and other leaders, including in these structures are the following: the First Nations Cultural Institute, houses and associations.
You are now on page?
I'm on page 25. It starts at 2527.
Are you
Volume 6.
repeating what was raised earlier?
I'm re- I'm-
24,
I'm-
25,
Indeed, I'm repeating.
25. Sorry, the page?
It's 2527.
Oh,
Yeah.
27.
So if my lady goes to paragraph 8,
Yeah, I don't have anything here. 7, 25. I don't have a list here on page 2527. Sorry, I'm just checking. Which paragraph are you?
paragraph 8.
8. 8.6. 7,
Starting at paragraph 7.4, sorry. my lady.
7.4. Oh, yeah. Yes, I see that.
Yeah,
Yes.
starting at 7.4, and if my lady even goes further back at paragraph 4, where we even included the supporting letters
Yes.
from the various houses as well. So, letters from the Griqua Royal House, letters from the Congress of Traditional Leaders of South Africa, which is the only structure that interacts with government.
Can you just repeat that?
The letter from the Congress of Traditional Leaders of South Africa is the only traditional structure,
Yes.
recognized traditional structure, that interacts with government in relation to So my lady, further on, as I said, the others is also the Khoi Cultural Heritage Development Council. That's at following from the National Khoisan Council and the Institute for the Restoration of Aboriginal South Africans. The Foundation, Nation Restoration, and then the Cape Khoisan Labour Forum. So that's the vastness of the collective, the First Nation collective that support this project. And all of them resort under the Cape Khoi. And the second applicant is the only one of those councils.
So second applicant falls in the first category.
Falls within the first category. Is the only one
Yes?
of the councils that have opposed the development. But they participated in the
Yes.
process. And their voices were heard. Their recommendations were incorporated. If not all of them, but some of them.
6 councils, 1, 2, 3, 4, 5, 6. But
And
you're still not answering my question. I'd like to know the total amount, the total number of councils within the Khoi and San groups. So you said the first group here, you have 1, 2, 3, 4, 5 divisions in the first group. Is this an all-inclusive group that is as indicated in the papers? Is it all-inclusive?
These are the known groups that are currently active and also groups that are currently participating in a lot of other traditional structures. Should there be tomorrow another group, my lady, then it could be probably a new formation. We don't know. It's probably an amorphous kind of
So is it safe to say that all interested groups were either consulted or informed about this?
It is safe to say that all affected groups
I see.
firstly have been informed about the development, given the opportunity to participate, and were consulted as well in the process, including the ones that have objected
Yes,
to the development.
thank you.
As a court, please, Mike.
Lady, there was an issue that I would like to discuss initially with the cameras and recordings off, if we may do that.
You may do that?
Lady, it relates to the accusation that was directed at me in relation to having misled the court. require a bit of auditing, apparently, and that's why I'm not in a position to support it right now. But apparently, that list includes everybody who participated, both people who were and people who were not First Nations people. But I'm told that an analysis can be done. But the primary submission is based on that reference that I originally gave you. I also gave it to you, I think, after lunch on Wednesday, which is a comparison of the list that appears in Mr. Jenkins's affidavit compared to the First Nation report and the difference between the two.
The issue with regard to the exclusion of certain First Nation groups was not raised in the founding papers. Is that correct?
Lady, if I can, part of my argument is to take you to the complaints about the AFMAS report, and I'll immediately concede it was not well pleaded, but there's a set of complaints that set out in Mr. Jenkins' affidavit, and that also your ladyship wasn't taken to. We would, and I'd like to be given the opportunity to work through that. In the course of my argument.
I will most certainly give you an opportunity, but I am concerned because one of the respondents referred to it as an ambush, and it's the court's duty to prevent that from happening. Because
Indeed,
we
lady.
are now at the reply stage, we're at the end of the road today, and for the applicant now to say that there were irregularities in the public participation process insofar as it relates to First Nation groups. It's a serious statement to make. It's a serious submission
Indeed,
to make
ma'am.
at this late stage. And it's not contained in the founding papers. The second applicant was actively involved at some stage. He withdrew at a certain stage. So most certainly that must have been information within the knowledge of the applicants at the time when they filed their papers. So I'm just raising my concern to you that the respondents could possibly be prejudiced if you making additional allegations of irregularities with regard to the public participation process.
Lady, if I can just get the references for you, but
Yeah, just tell me
certainly
which volume so that I can get it out.
I'll immediately concede that it was imperfectly pleaded.
Oh, it was.
But there are references to it, and the important one that your ladyship's attention wasn't drawn to by my learned friend is the one where Mr. Jenkins sets out his complaints in relation to the process. I think your ladyship is correct. It may well be that he doesn't refer expressly to exclusion, but certainly our submission would be that the impact of his methodology and his approach was effectively to result in exclusion.
Are you referring me to somewhere in the record? I have volume 5 here.
If you can just bear with me.
Yeah.
So page 74, lady.
74. Would that be volume 1?
Volume 1. And there it says, while the formal requirements of PADJA were complied with, the consultation was not meaningful. It is clear and they rely on
You are reading, where are you reading? Paragraph?
paragraph 135.5.
Point 5. 135, yes?
It is clear to the Heritage Western Cape that there has been a lack or avoidance of meaningful consultation with First Nations groups. Heritage Western Cape is further disappointed that in the instances where comment has been received, this comment has seemingly been dismissed as a difference of opinion rather than a meaningful interrogation of the concerns raised. So I accept that it's not perfectly pleaded, but when we say absence of meaningful consultation, we would submit it would be legitimate to examine the documents upon which the record is based, and to say from that, and your ladyship to infer that a group of
Is
people
this
were
a
left out.
quote from somewhere? This is a quote.
Indeed, lady.
Where would that be in the HWC's comments or
I
report?
think it's in their letter of 13 September 2019.
Yes.
It's the letter of
Interim-
13 September 2019, if I remember correctly.
So this is a quote taken from a letter
Indeed,
that
lady.
where HWC made comments with regard to.
Indeed, lady. But I mean, one of the bases upon which the applicants are criticized is they've hung by the coattails of the Heritage Western Cape. But, milady, yes, that is how we pleaded our case, and there was a logic to that because of the fact that they're the ones who dictate the requirements. So the respondents can't have it both ways. They can't say you hang on the coattails of Heritage Western Cape, but when there is something that Heritage Western Cape has said that is relevant in that regard, we can't claim that as part of our pleaded case. So
What
we
is
say
the
that,
date of this letter?
I think it's 13th of September 2019.
2019.
Pardon, lady, it's the final comments of the 13th of February
Final comments.
2020.
Can I have the date again? 13 September 2019.
2020. What I first said was the 13th of September 2019.
Is that final comments?
No, the one I've just read to you, I'm told, is the 13th of September 2019. And
And the final comments date, was this the date of the, I'm just consulting my notes, but maybe you can assist the court. What is the date of the final comments?
so the final comment was the 13th of February 2020, and that starts at page 270.
But the applicants on their own version, they do not have any other objective evidence that points to failure to consult,
It points
except
to?
to rely on HWC's comments. Is that the position?
No, I'll come to Jenkins' affidavit, and
Yeah.
he sets out all of his complaints in relation to the AFMAS process, and that was with the founding affidavit, so it's certainly part of the case that was presented. But I think there's also a paragraph then of the letter of the 13th of February 2020, if I can just get the relevant part for you, milady. Page 278. I think it's still volume 1, if I remember correctly. And page 278.
278. Is this final comment? Check the date.
Indeed, ma'am.
Yes. Paragraph?
Paragraph starts paragraph, it's got E, and then below that paragraph 96.
Sorry, paragraph E.
E, and then below that 96.
Yeah.
So E reads, results of consultation with communities affected by the proposed development and other interested parties regarding the impact of the development on heritage resources. 96, it is noted that the applicants have conducted an engagement with First Nations grouping, which culminated in the First Nations report submitted to HWC on 4 December 2019. There are a number of issues with this report, namely, A, the scope of engagement resulted in a number of groups electing not to participate fully. The research process was contested by participants in the engagements. The impartiality of the research questions is not clear to the committee. The methodology for the engagement does not appear to follow accepted oral history interviewing protocols. For example, no ethical clearance forms were supplied. Confusion between this report and the Department of Transport and Public Works Commission report brings the
Can you
ethics
pause
around
one
the
moment,
engagement
please? I'm only interested in the public participation aspect of what you refer to now. The applicants didn't raise this issue in their founding papers. So what does 97(1)A mean? Can you contextualize it for the court, please? You cannot make a vague statement and then you don't substantiate it, because I asked 8 respondents to give an indication of the figures, how many groups are there, how many groups were excluded, etc. The applicant relies on AWC's submissions, and the court did debate that issue already, because HWC withdrew from the process at a very crucial stage when the minister required assistance. Now, what does 97(A) mean for the applicants? Not the HWC, what does it mean for the applicants?
Well, that I don't think is on record. I don't think I can refer to an affidavit that says what's on record, except to the extent that it's taken up in Mr. Jenkins' supporting to the founding affidavit. And lady, I think we can only fairly judge it once we've had a chance to look at that.
But I need to ask the question directly, because we're at the end of proceedings today and public participation is very important. So if you can direct me anywhere in an affidavit, a document, to clarify what A means to the applicants, where will I find Mr. Jenkins' affidavit? I don't want you to move to any other point. I want us to stay with public participation, because I don't want to muddy the waters and then we refer to other issues, whereas public participation is very important. And all the parties already addressed the court on the issue of public participation. So, which volume will I find Mr. Jenkins' affidavit?
As this paragraph is concerned, I don't think it's taken up further anywhere else in the affidavits. And no one's correcting me as I say that. But as I say, if we can have a look at the relevant part of the Jenkins affidavit, because that's part of the founding papers. And again, the reference is quite deep into my argument notes, so that's why I'm taking time to get there. But his affidavit appears at volume 2, page 709, is the start of the affidavit. Page 731, paragraph 55. It says, at or around the time at or around that time that Mr. Arnsel presented his Trap First Nations report to a stakeholder group at
Sorry,
Oudtshoorn.
pause for a moment. I'm just organizing my
Beg your pardon.
space here. Page
731.
731. 731. Paragraph 54?
55.
55. Thank you.
At or around the time that Mr. Arendse presented his Trap First Nations report to a stakeholder group at Oudtshoorn, as part of the HIA public participation process, it came to my notice that he had been engaged by the developer. In our view, this meant that Mr. Arendse had a conflict of interest. The impetus for the additional engagement process was because First Nations groups had been unhappy with the lack of meaningful engagement with them by the developer and the consultants. And now the person facilitating that process was under contract to the developer. This, coupled with my earlier concerns about the absence of proper ethical safeguards, convinced me that Mr. Arendse was not to be trusted. Consequently, the Gurungai Corner refused to engage further with Mr. Arendse. So already one sees a reference there to unhappiness with the lack of meaningful engagement with them by the developer. So with respect, that is certainly a complaint about a form of exclusion or dissatisfaction with the process that was being engaged in. And with respect, my lady, the AFMAS report, when we talk here about a failure to consult, we're talking about a failure to consult in terms of paragraph E of section 38.3. We're not talking about a failure to consult under PUDGA. We're not talking about a failure to consult in terms of the environmental impact assessment regulations of 2014. And I'll come back to this to make specific submissions. But in relation to, and let me make the submissions now before we go further. That paragraph.
Can you just pause one moment? Paragraph 55. The paragraph referred to additional engagement. It says additional engagement.
My understanding is that he's referring back to the first TRAP report, and the additional is, as I read it, what's coming now directly with the developer, the process that's been initiated by the developer in response to the 13th of September 2019 letter that's been received from Heritage Western Cape.
I also don't see any statement in paragraph 55 that a specific group was excluded. I don't see it there.
Well, it doesn't
It's vague.
identify a particular one,
It
but
is
it does
vague,
say
yes.
First Nations groups had been unhappy with the lack of meaningful engagement with them by the developer.
Is the applicant, or I must say, are the applicants, I don't just want to refer to second applicant, are the applicants in a position to tell the court who were excluded from the process today, as we stand here today? Are the applicants in a position to identify those groups?
On the basis of the earlier exercise that I showed you, which is to compare the relevant part of his affidavit where he lists the groups and contrasting that with the First Nations report. So let's do that exercise, lady.
Second applicant participated and subsequently withdrew. So second applicant's position is clear to the court. The court needs clarification.
In relation
Were
to the
any
others.
other groups excluded, and the court cannot find it in on page 731.
Indeed, lady, and there what I've said is that there are two potential sources. The one we've already drawn to the court's attention, which is a comparison of the list that comes later in his founding, if I can call it founding affidavit, compared with the list in the First Nations report. So the difference has to be those who weren't consulted, because Arendse's report is finite as to who he was consulting with.
How can the court ascertain whether any groups were excluded if the applicants cannot contextualize it, verbalize it, and provide the court with that information?
That's the that's the best submission I can make. In addition to the list that I said that we would provide to your ladyship by way of a table, which comes from the appeal in relation to the provisional protection order. I can't do better than that. It isn't articulated better than that.
Does it mean that the applicants are incapable of providing the court with a list to state unequivocally which of the First Nation groups were excluded from consultation and participation? Are the applicants not in a position to provide that information by mentioning the names of the groups?
If, as I understand the process that has been permitted in respect to the 8th respondent correctly, and I speak subject to correction, and we were allowed a similar process where we could go outside the record in the proceedings, then I have no doubt that we would be able to provide a list. If I'm understanding the procedure that is being engaged in by the 8th respondent, and it seems to me that the applicant should in those circumstances have a similar opportunity to identify those who were left out through a process that's extraneous to the record.
Well, the applicant, the 8th respondent clarified to this court that there were 6 groupings in the first, let me just check my notes that I made. That is without any note or any additional information. The 8th respondent, oh, sorry, where am I now? Oh. The first group there were 8 different groups within the first group. And apparently the second applicant forms part of that first group. So the second applicant is the only group in the first group that did not participate until the end. He did participate, or they participated.
In the original
Yes,
TRAP report.
yes,
Indeed,
but not the second leg of the...
Indeed, my lady. But I didn't understand, and I speak subject to correction, I didn't understand the information coming from the 8th respondent to be referenced to specific places in the record where one could identify that.
No, the 8th respondent, sorry, I'm just looking for my note. 8th respondent, but perhaps the 8th respondent can just remind the court the reference of the page, please.
At volume 6.
Volume 6.
And it was from the founding.
Learned friend lady through the mask. Apologies.
And it was from the founding. And it was from the founding affidavit of Charles Jackson, and
Oh yeah, it's 2530. Sorry, I found my note. You mentioned that there were 5 houses.
Correct.
Within the first group, there were 6 divisions. 2530. Let me just check.
and I've read from paragraph
2531.
from paragraph 7.4, where I refer the court to, firstly, to the 5 houses generally, and when it came to the Cape Koi house, these are the groups in 7.4.
Yes.
And
Forms part of the first group.
they form part of first group, indeed.
And second applicant formed part of
and the
that
second
group.
applicant formed
Yes.
part of the first group,
Yes.
but opted out of the
Yes,
process.
at some stage, yes. So so 8th respondent referred to the papers.
As the court pleases, there were two other sources. The one is the list of participants in the appeal process in relation to the provisional protection order, and unfortunately that isn't in hard copy form yet, but we can arrange that. And I asked my attorneys to make sure that they referenced First Nation people who were specifically referred to in the record. This is all from the record, lady. It looks like
Volume?
1561. In fact, it starts at 1562, according to my version of the record. And so in our analysis, it's Ms. T. Walensky, who's coroner,
I'm not with you. I've got
page
volume 2 here.
1562. And I'm told that the grouping that they belong to can be determined with reference to Mr. Jenkins' affidavit.
Sorry, I cannot hear you.
I say that I'm told that the grouping that they belong to can be referenced through reference to Mr. Jenkins' affidavit. And if one looks at both of those documents, I'm told that Ms. T. Walensky is there as coroner. Mr. K. King is there on behalf of the Kochokwe Traditional Authority. Kai Coroner Transfrontier under Kubaha Melvin Orense. Captain J.C. Witboy. It's spelled W-I-B-O-O-I, but should be W-I-T-B-O-O-I.
Can you just repeat the reference? Which volume are you in now? I have volume 6 in front of me.
Volume
So
4, my lady.
volume 4.
Volume 4. Page 1562.
Page
1562.
1562. Yes. This list represents interested and affected parties.
Indeed, my lady.
So what is the point that the applicant is making at the moment?
So the point I'm making is it provides us with another list of people in respect of which we can do the same exercise and contrast this list with the list in the at the beginning of the First Nations report.
Oh, this is an annexure attached to the appeal record. Is this an annexure attached to the appeal record?
That's how I understand it, lady.
The applicant never referred to any irregularity with regard to the public participation process insofar as it relates to First Nation groups. Why are the applicants relying on documents emanating from other sources?
Lady, I accept that that's the best that I can do in
I
terms of
see.
identifying people who weren't consulted.
Yes.
But there are other aspects of the process that we say are non-compliant with paragraph E, which render the report non-compliant with that paragraph. And that's where I'd only read the first paragraph of Mr. Jenkins' affidavit in that regard.
Is my understanding correct that the applicant, that there are no indications in the founding paper, in the founding papers with regard to lack of public participation of any group belonging to the First Nation?
We can only determine exclusion through inference.
Yeah.
But the complaints then continue on page 732, my lady. And it's 732, and it's
So
volume...
it's concluded through inference, based on information and reports and comments provided by other parties. Is that what you're saying?
Yes, it's a case of contrasting the First Nations report with the two lists, the one in Mr. Jenkins' affidavit and the one attached to the appeal record. And then 732, I think, is volume 2, lady. Paragraph 56. Mr. Jenkins says, our concerns were vindicated when we saw Mr. Orance's report entitled River Club First Nations Report, which purports to be an investigation of the aspirations for the site on the part of the First Nations people, the AFMAS report. And then 57.
Which page? Can you give me the first reference? I'm making a note. Volume 2?
732.
732.
32. And again, I emphasize, my lady, this is part of the founding papers.
Yes. 734. Just see. Yes.
So he says the AFMAS
Paragraph
report.
56. Yeah.
So, yes, it was 56, he says that when he sees the report, his concerns were vindicated. And it's worth remembering that his starting point was a concern about a conflict of interest on the part of Mr. Orance. And that has a resonance with the submissions that were made by the amicus, when he said generally the process should be run by the state, or at least checked by the state. And so while one's initial reaction to his sensing a conflict might be one of doubt, seen in the light of what we learned about the requirements of international law in relation to consultation, that has validity. One can see why they're concerned that the state should be the party that is overseeing the process. So in paragraph 57, the AFMAS report, and he lists his complaints, downplays and obfuscates the significance of the area and its associated intangible heritage to the Gurung High Corner and other indigenous people, seeks to delegitimize the view of the Gurung High Corner Khoikhoi Indigenous Council, seeks to undermine the standing of the chief of Gurung High Corner and to portray the Gurung High Corner as lacking credibility to speak about the significance of the area, elevates the First Nations collective as the authoritative voice of First Nations peoples in relation to the proposed development, and seeks to portray proposed development as a victory for the First Nation peoples. The AFMAS report includes WhatsApp screenshots to portray the chief of Gurung High Corner as unreliable or unstable. To my knowledge, no attempts were made by the author of the report to get the chief's comments, to verify such screenshots, or to place any such comments in context. The AFMAS report also quoted parts of my previous interview by Mr. Orance without acknowledging me as the source, and despite my having made it clear at the time of the interview that it was not to be used in support of the proposed development. The report characterizes the Gurung High Corner as drifters and outcasts and presents extracts from the diaries of Jan van Riebeeck that describe the Gurung High Corner as this ugly Hottentot race, a gang who are lazy and never set hand to work until you have promised to give them a good quantity of tobacco or food or drink. They live by begging, stealing and robbing. In contrast, the Gurung Haikwa, the group currently in support of the proposed development, are presented as the traditional custodians of the historic landscape that encompassed the River Club site and the broader Two Rivers area. The use of these extracts from colonialist diaries, which are replete with racist assumptions and prejudice, is clearly to attack and undermine the Gurung High Corner in our opposition to the proposed development. The AFMAS report also uses examples from other First Nations groups around the world and posits them as precedent that can be applied to the River Club site. This implicitly but misleadingly positions other First Nations groups as having been aligned with the proposed development. And with respect, that goes to the heart of what a proper consultation process backed by international law should involve. The trust element is completely missing. The treatment of everybody as like or equal is missing. The good faith element is missing. The goal to reach agreement with not just one group, but with all all groups is missing.
I cannot see any indication from all the paragraphs that you have read. The court is still in the dark as to which groups were excluded and which were not.
I accept, my lady, I've stated what the best case is that we can make as far as that is concerned, but the submission I make is these are additional considerations pleaded in the founding affidavit that in interpreting paragraph E would have to be taken into account if your ladyship was going to comply with the obligation that with respect rests on the court in terms of section 39 1B, I think it is, which obliges the court to take into account international law in the interpretation of paragraph E. And that wouldn't just involve consulting with everybody. It would involve a number of the other elements that Mr. Bishop referred to in his argument. And those cross swords, as it were, with some of these complaints. And with respect, the complaints here, one looks at the report, yes, they're not exclusion complaints, they're different complaints. But there are certainly complaints that could have resulted in exclusion. And even if your ladyship is not convinced as far as that is concerned, in terms of meaningful engagement and the fact that it has to be interpreted with reference to judgments about meaningful consultation, like the Scalabrino judgment about what has to take place in a consultation, these complaints we submit would successfully knock out that as being a compliant process. That's the submission we make that we make in relation to that. Not just the exclusion. We say, yes, we have a case that is not ideally pleaded in relation to exclusion. In relation to the other complaints, we say, yes, the case is ideally pleaded. Your ladyship's attention wasn't drawn to it by my learned friend when going through these. And it's in the founding affidavit, lady. So those would be the submissions in relation to paragraph E. If I can then come back to where I was going to start. But I want to start by dealing with the OTA judgment under the rubric prima facie right. First respondent argues that the prospects of success in the review should play little, if any, role, and that this is really a case about the other elements of the test for an interim intellect. And I think that view is shared by other respondents too. The main case for that proposition is OTA, where it says the prima facie right a claimant must establish is not merely the right to approach a court in order to review an administrative action. It is a right to which, if not protected by an interdict, irreparable harm would ensue. One can see exactly why in that case that had to be said. If one goes on to read what the threatened harm was, that's at paragraphs 53 and 54 of the judgment. The respondent's case was based on financial harm to motorists and persons in the transport industry. There was no constitutional right that was being threatened. That is why the court said that the element of impending irreparable harm was wanting, and a reasonable prospect of success on review was not good enough. We say that OTA is distinguishable in two respects. From the applicant's side, they are not fighting about money. They are fighting for their right to their intangible heritage, and importantly described as living heritage in the statute. The respondents are all at pains in these proceedings at this stage to say that they recognize fully the intangible heritage resources that reside in the site in its entirety. First respondent itself acknowledges in their heads of argument that it is an associative cultural landscape, and I emphasize the word landscape. And I also emphasize the word associative. The word associative correctly conveys that the intangible heritage is inextricably linked to the land and the landscape. Paragraph 105 of their heads of argument, they say that, and I quote, "The specialists recognize the cultural values associated with the site as a floodplain," so in other words, the entire area, not just the rivers, "as the place of early confrontations between indigenous peoples and settlers. This significance, taken as a single complex of significance and symbolic meaning, is regarded by the HIA as being of the highest order in the current socio-political landscape. We submit that in those circumstances, the rights that are threatened with irreparable harm are not established prima facie. They are absolutely clear, Lady. And that's on what's common cause in the discussion over the last 3 days. What is more, they are indeed, contrary to what the respondents would have you believe, they are indeed constitutional rights. This court is precluded with respect both by Section 39(2) and by the principle of subsidiarity from ignoring the fact that we are dealing with constitutional rights simply because they were not expressly referred to in the founding affidavit. The rights are rights to culture in Section 30 and 31, and the related rights to equality, dignity, and a sustainably managed environment. And the importance of Section 39(2)(b is that the court is, with respect, obliged to interpret a statutory provision having regard to the spirit, purport, and objects of the Bill of Rights. So even if one relies simply on a statutory provision, particularly one which is there to provide an element of one's cultural rights, automatically the Constitution requires the court to engage the Constitution. So there can be no suggestion that we haven't established a clear right that is threatened with irreparable harm, and that that clear right is made up of a number of constitutional rights. As was correctly pointed out in the Shell case, in interim interdict proceedings, the fact that constitutional rights are at stake weighs heavily in the applicant's favour. It's also acknowledged in various of the respondents' HIA reports that heritage resources will be negatively impacted. For example, at page 171 in the July 2019 version of the Heritage Impact Assessment, the consultant said, and I quote, "The greatest negative impact of both the preferred riverine corridor and island alternatives on the floodplain as a whole and the site and surrounds is that the proposed development will result in a fundamental change in the appearance and character of the site, which has been perceived as a negative impact by almost all commentators." Coming from the respondent's heritage expert. How then can it be suggested that the intangible heritage that one associates with an associative cultural landscape is not permanently harmed by the transformation of that very landscape from an open green space to one with massive buildings reaching in various instances to 10 stories, plus the raising of the underlying land? So we say, whatever your interpretation of OTA, we're easily home and dry on OTA. Before moving away from OTA, the second basis upon which it is distinguishable is that they were there, the parties who successfully got the interdict in the High Court were attempting to interdict government itself. It was the target of the interdict from implementing decisions pertaining to the establishment of toll roads. That meant that there were very serious separation of powers concerns that were raised. And the judgment is has several warnings about how carefully the courts need to tread in that situation where you directly interdicting the government. We aren't interdicting the government in these proceedings. We're simply interdicting the developer, a private party. So we really sit under the traditional law, as it were, in relation to interim
Can you pause
interdicts.
for a moment? What is the current position with regard to the review proceedings?
With
from
regard
the
to that?
perspective of the applicants?
I'm afraid I didn't hear you. You said, what is the current position in regard to that?
The review proceedings from the applicant's perspective.
Well, as far as the review proceedings are concerned, lady, as I understand it, we now await the provision by the authorities of the Rule 53 record. As soon as that record is provided, we can respond. My sense, although I haven't explored it, is that the record must be several weeks, possibly we're into months late, because I think there's a 10 or 15-day time limit in Rule 53 as to the provision of the record. So that's where we stand. As soon as the record is provided, we can get on with preparing the supplementary affidavit. And, lady, let me make absolutely clear, my instructions are to tender full cooperation in ensuring the speediest review proceedings. My learned friend would have you believe that it's an inevitable story of delay. We have more faith in a judicially managed, if necessary, case management process, which could ensure that this gets there fast. A lot of the necessary water has already flowed under the bridge. Most of, if not all of the important documents are in fact already part of the pleaded case. There is no reason why one shouldn't quickly get into a position where it's time for further affidavits to be filed by the respondents. And let's think about it. They've put up very substantial affidavits already justifying those decisions. There must be a limit on how much more they have to say about it. So we don't see a 12 to 24 month inevitable delay. And as I say, we tender full cooperation as far as a speedy review is concerned. And coming back to the tests on prima facie, the other case that was referred to by the first respondent is the South African informal traders case. It was decided subsequent to OTA and confirms that there is no intention to introduce any variation in the legal regime pertaining to interim interdicts. Because the Constitutional Court confirmed that, and I quote, a prima facie right may be established by demonstrating prospects of success in the review. And it refers to the 1973 judgment of the Appellate Division in Ericsson Motors. So our submission, lady, is that the law has not changed. But even if it has, on the first respondent's interpretation of OTA, the requirement of demonstrating irreparable harm to a prima facie right is more than adequately demonstrated on the common cause facts and on the respondent's documentation to which I've referred, Your Ladyship. It's also significant, the first respondent refers to cases such as Beck's case, which confirm the principle that if the review is shown in the interim interdict proceedings to be based on a particularly strongly established review ground at this stage, then the approach is the sooner the building is stopped, the better. And we submit that that is precisely the position in this case. Milady, to come back to an aspect of the discussion around the interpretation of the statute, much of the debate has focused on what the implications were of the Interim Assessment Committee failing to attend a workshop and a meeting, and Heritage Western Cape's not having responded differently to the correspondence from the minister. They responded, but the complaint is that they should have responded in a more forthcoming fashion. Our submission generally is that if objectively assessed, the requirements of Heritage Western Cape in their letters of 13 September 2019 and 13 February 2020 were in fact clear, and objectively assessed, the heritage practitioners did not respond to those requirements. A subsequent unanswered request for clarity, where clarity already existed on the record, cannot retrospectively undo what took place on record and under the statute. Moreover, if the record shows that such clarity already existed, then there is a limit on the criticism that can be directed at Heritage Western Cape for simply referring back to the clear documents when the minister corresponded with them. Nevertheless, even if the court is against us on those submissions and were to hold that the letters of 13th of September 2019 and 13th February 2020 must be totally ignored as a result of Heritage Western Cape's conduct, and we submit that would be a difficult thing to justify with reference to the clear compulsory terms of the peremptory terms of the statute. We submit that in any event, the statute imposes information requirements in and of itself, regardless of what Heritage Western Cape may or may not require, and regardless of what they may or may not subsequently do in relation to the minister's subsequent decision-making process. So just for purposes of refreshing our memories, if we can just have a look at the opening part of section 38.3. It says the responsible Heritage Resources Authority must specify the information to be provided in a report required in terms of subsection 2A, provided that the following must be included. So even if one had a situation where they were completely supine, they did nothing, Heritage Western Cape, in terms of specifying the information requirements, the statute would kick in and would require compliance with every one of A to G. On that basis, we submit that there is still really no answer to the flaws that we have identified in our main argument, particularly in relation to the supplement at pages 30 to 39 of the notes for oral argument. Those haven't really been addressed, and save in the limited respects I'll refer to, we stand by what is said there.
How would those flaws have impacted on the minister's decision?
The flaws would have impacted on the minister's decision because if one looks at the proviso in section 38A, it is peremptory that they have to satisfy the requirements of section 38.3. There's no way out of that, number one. It isn't to the extent that the director or the minister considers necessary. It doesn't say to the extent, such as is in the opinion of the director or the minister necessary. Those subjective kinds of wording that signify an element of discretion are simply not there. So what the decision maker, director or minister, has to do is before they get going with any decision-making processes, first see that section 38.3 is complied with.
So what type of information would have impacted on the minister's decision that was not provided?
If I can then come to that. So I've already made a reference to, and for the purposes of saving time, I don't want to go through it again, but I went in quite a lot of detail through the supplement, and the notes that we handed up deal with what we say in relation to each and every one of the sections of the supplement. We go right through to right through to, I think it was section 6 or something like that. We worked through the various sections. I'm not sure if your ladyship would like me to go there again. It wasn't seriously taken up by any of the respondents.
Look, it's common cause that the property is of great historic and cultural significance, has both elements of tangible and intangible heritage resource value. What additional information could have prompted the minister to refuse environmental approval? Even if you give the highest level of cultural and historic significance, the highest level of tangible and intangible heritage value significance, how would that have impacted on the decision made by the minister?
The first submission I'd make in that is that, in fact, on a reading of the statute, it doesn't matter. It simply has to be done. However we might here in court
Can you
view
just
it.
remind the court what was not done?
Well, if I can
I'm looking at, I have your notes here in front of me. Can you just indicate
So-
it? You said that you
Yes, so I'm going
highlighted
to deal,
it.
I'm going to deal with
What
some.
was not done?
So there are two things. The one is, and let me give your ladyship the reference.
Look, the fact that Mr. Arendt's qualifications and methodology were criticized, the fact that his conduct or his impartiality may also have been questionable. The court noted the concerns raised by the second applicant.
That's part of it, lady.
Yes,
So just
but
to,
how does it assist the minister to arrive at a different conclusion? The fact that Mr. Arendt's didn't follow the correct methodology or whatever criticisms they have. So remove Mr. Arendt's from the equation and explain to the court, besides criticism of Mr. Arendt's methodology, etc., what is the nature of that information that was lacking that could have prompted the minister to refuse this application?
can I take you initially through it? I can do it paragraph by paragraph. And
Where-
then
where will you take me to?
if you're not here in my argument, and if your ladyship wishes me to, then we can move on to the comments in the original notes on the supplement. But if I can start with paragraph 38.3a. 38.3a says there must be both identification and mapping of all heritage resources. The paragraph requires two distinct processes, identification and mapping.
Did
means
mapping
what-
not take place at all? Or was the mapping insufficient? Or was insufficient weight attached to the mapping? What is the position?
there was a serious shortfall in the mapping itself, and I'll take your ladyship now.
So there was
to-
a shortfall.
I'll take your ladyship now to the maps, so we can see where the shortfall lies. So we said that there must be a map that shows all of them. It must be prepared by the heritage assessment practitioners. No such map has been drawn to the court's attention in any of the 3 days that we've been arguing
Is there
about
anything
this
that
case.
would be included in that map that is not on record at this stage?
I beg your pardon?
Is there anything in the mapping process that
That's not on
should
record.
have been included that is not that does not form part of the record? You know,
Not.
we have an idea of what we are dealing with, isn't it?
I don't think there's anything other than it's 5 diagrams that I will refer your ladyship to. And
So the
fir-
diagrams, what's the word that you use? It's
I
insufficient.
said diagrams. I mean maps. So let's assume in favour of the consultants that these were maps, and if we can start at page 2518. And we're looking now at the July 2019 Heritage Impact Assessment. I think it's volume 5, lady,
2518.
2518.
Yes, I'm with you.
And we see on that page what is described, in fact, as a diagram,
Yes.
figure 31. And what we have helpfully there is a dotted line showing where the development is. And your ladyship will see that it's completely empty. And then at the bottom it says, diagram of current significances of the riverine topography as cultural landscape. It's very difficult to understand what is being spoken about, but one thing's for sure, there's no mapping of heritage resources, tangible or intangible, on that diagram. then if we turn the page to page 2518, I beg your pardon, 2519, we see figure 32. It's again got a dotted line indicating where the development is, and there's a bit of black shading now that comes into the development area, presumably referring to the envisaged water. I imagine of the rehabilitated canal is my guess. And it says, diagram of future significances of the riverine topography as cultural landscape after restoration of the Lesbiac River. So again, there's no attempt at all.
What would the purpose of mapping be?
The purpose of mapping would be to see what tangible and intangible heritage is there and what it is associated with. And the fact of the matter is that the legislature has decided that that's an important exercise to engage in. And it would seem to me that a visual depiction would make sense in these circumstances. It would assist.
How would a visual depiction impact on a decision? We know where the rivers are located. We know where the position of the mountain, Signal Hill, or whatever. We all know what we're dealing with. And I'm just interrogating this aspect of mapping to see what is it about the existing maps that is lacking, because intangible heritage resources is an abstract term. It's an abstract term. An intangible heritage resource. It's not, you cannot necessarily draw it. You cannot draw a poetry session or a ritual that took place. You cannot draw it next to the river. I'm just making an example now, just giving examples.
Lady, it's an associative cultural landscape, and there would be different parts of the landscape that would have different associations and meanings. And it would force the heritage impact assessors to explore those meanings and to explore how they interlink with the different parts of the site. And so, for example, lady, perhaps if there had been a proper consideration to mapping the green open space in the middle and working out, for purposes of the mapping, going through the mental process of working out what the association was with a particular form of intangible heritage and exploring that with the communities involved, it may very well have been a helpful process to go through and might have assisted
And assuming
them.
the mapping was done completely as envisaged by the applicants, what does the applicants predict would have happened? Would there not have been approval for this project? Is it as serious as that? This shortcoming with regard to mapping? Would it materially have impacted on the decisions made with regard to the River Club project?
We submit very likely yes, if it had been done in an objective, independent, impartial manner that weighed each of the impacts, each of the resources, their significance, the impact of the development on each one, and a weighing of the impact against the socio-economic considerations. It may very well have led to a different decision. But, and I'll come to it, part of the difficulty here is this was always going one way. So if your ladyship's conclusion is, given these facts as it was only going one way, yes, we agree with you, lady. This was only going one way, and that was towards approval, and it didn't make a difference what you did because of that initial, not even binary indication of lack of alternatives came right in the preface to the 2019 Heritage Impact Assessment, and we see the same attitude prevailing at the end of the supplement. So we agree with you, lady. Yes, with these assessors it was going one way, but done properly, it may very well be that a minister who had a good consciousness of culture and intangible heritage would have said, gee, this place is special in South Africa's history. This place is a place that can bring about reconciliation that our country so desperately needs. This place, if we think about First Nation peoples, is one of the few remaining places where they can evoke their intangible heritage. And he might say, yeah, I think maybe this is something where we've got to look at it differently, look at a different vision for this land.
So there's a possibility that the minister could have imposed different conditions. Or there was a possibility that the whole project could have been rejected.
Could have been rejected, lady. Could have been rejected. Could
So
have been rejected.
assuming the court is with the applicant and the court is of the view that had some of the insufficient details been provided, it's possible that the minister could even have refused to approve the project, be it just environmental or both land use and environmental. What is it that the applicant wants? What must
Sorry,
happen?
what must happen to
Yes, to the property. Assuming the court is with the applicant and the minister would possibly have been with the applicant and imposed different conditions or reject the approval, reject the application for environmental approval or land use approval. What is it that the applicant wants?
Well, one saw in that list what looked like their ideal possibility was, which was that it becomes an international heritage site. That's how importantly they assess that particular land.
But were those processes triggered by the applicant or accessed by the applicant?
Well, those processes don't, as far as I read the National Heritage Resources Act, don't enable a private person to apply, for example, for a heritage to be created. They don't own the land.
But I don't think that it's sufficient to make that statement.
But
Are you saying the onus is just on the state to decide what is going to be a heritage site or not? We have very, very vocal civil society groups who can take action, or any individual person can take it upon them to promote the declaration of a site as a heritage site, albeit national, local, national, it doesn't matter, international. Are you saying that it is in the state's hands as to whether an area will be declared an international, a heritage site?
my understanding, and I hear your ladyship, my understanding is that they did indeed act in that way, and I think it's exemplified what happened with the earlier TRUP process. I think they were involved in that in a very vibrant way.
Suburban park proposal.
And I think that was one of the things that was considered in the earlier TRUP process.
Is that what the applicants want?
No, as I've indicated, I think their ideal would be a World Heritage Site, but certainly it's got to be something that remains of the status of open land.
When did the applicants decide to? I will use the word. I'm using the word cautiously. When did the applicants make the decision that this area needs protection to the extent that it should even be given World Heritage status? And I'm asking this question in the context of a golf course. You have a golf course at the River Club. Did the applicants do anything to promote or this land, the pocket of land, to be declared a heritage site?
I've mentioned the one. I mean, I think part of their submissions, they specifically said that their vision was in the one that was referred to, I think, by counsel for the 8th respondent, one saw there the reference to this particular vision. But
The fact that you have a vision does not mean anything. You must take decisive action. This is your heritage. You want it to be preserved and protected. I'm trying to establish that the first and second applicants have no problem while the property was used as a golf course. There was no problem with that. Is that the position?
My recollection of reading of the record doesn't enable me to respond as to whether I can find something on the record, and I can ask that be checked, and if necessary, I can also ask if there is something that isn't on the record, as far as that is concerned. I don't know how far back it goes, but one must remember, with respect, as your ladyship pointed out, its history is very much tied up with its colonial past, culminating. I mean, certainly, I don't think any of my clients would have been welcome at the South African Railways Recreation Club during the times that it was being converted for that particular use, and even less so before then.
You see, if the court intervenes, the court must at least know there's going to be some benefit for the court to stop the project. Because it appears as if the developer is saying, look, we'll continue with this building at our own risk. Let the review go ahead. If we need to break down the wall, reduce the levels, if you're on the 5th floor and we must break down the walls, we'll do that if it's required of us. So I need to know what is the benefit for the applicants if the court stops the construction. Yes, the review is going to be heard, but I need to know beyond that. What is it that the applicant wants, and is it feasible? Is it doable? Is it sustainable? Is it economically viable? Should the court stop this, building the construction at this stage?
Well, lady, it seems to me that there is something in the nature of a case for that to happen, because at the moment it is being investigated by Heritage Western Cape, formally proclaiming the area. And that is a statutory option, and I'll come to where the reports fall short as far as that is concerned.
But the problem is the provisional protection is no longer valid. So the court is not even sitting with a piece of land that is being provisionally protected, because that could even have made it could have made the court's life a bit easier, the decision easier. You have a piece of land, it's protected, it looks as if it's on its way to attain some form of status, and it looks as if the conditions that were posed could possibly be tweaked a bit. So,
well, if you're putting it the level on its way, it seems that, and I think that is on the record, that is a distinct possibility, because it's under consideration at the moment. So, and we would submit that's, particularly if one looks at what the alternatives were that had to be considered.
so I would imagine.
That's good enough, we would say.
So I would imagine if this court is not with the applicant, and this court decides construction can proceed, it's at their own risk, they must just suffer the consequences after the developer and whoever must suffer the consequences after the review is heard. By the same token, this court, I just lost now my thought process now. Oh, yes, this is what I wanted to say. But by the same token, the court can say construction can proceed, and if the court grants that order, that the construction may proceed, what the applicant is saying now is, once the court hands down that order, there is a possibility that the site may be declared as a protected site after the court hearing. So, should that happen, in that eventuality, would the applicants then not be in a position to come back to court and say, look, now we have a place, we have property, it's the site has provisional protected status, and we want the court to reconsider its position. I'm just throwing it out there to ask the applicant, because there is nothing definitive, there's no concrete, nothing concrete for the court to hold on the idea that the property will be declared a heritage site as we sit here today. There's nothing.
Well, I don't think one can say nothing, lady. In fact, I put it to you incorrectly. The position's a little bit stronger.
Yes.
Because the body that's considering it, I was wrong saying it was Heritage Western Cape. It's the South African Heritage Resources Authority that is presently investigating the declaration as a national heritage
see.
site.
Yes.
And with respect, lady, that puts it at, I would respectfully submit, quite a high level. Because what you will then have is a developer who's not only acting illegally with reference to the rule of law, but on top of that is preventing another lawful statutory process from going ahead at national level. And we know from the record that the area, from the point of view of the freedom struggle, has a real significance. The battle that's a little bit controversial, and we can debate it, was referred to by the president in one of his speeches.
But that is a different application to come to court and say, we are seeking an interdict to stop construction on the basis that this site is currently being considered as a national heritage site. That is a different application. It's actually a much easier application than this one.
Certainly, that's obviously one of the things that could happen.
Yes.
At the same time, one have to take into account the perhaps hesitation of state bodies to get involved in litigation.
Yes.
But it doesn't eliminate it as a very relevant consideration for the current matter. Highly relevant consideration for the present matter. And there's a statutory, and as I'll come to, there's a statutory basis for that, which I think hasn't been correctly understood in the proceedings to date because of a misinterpretation of the alternatives provision. So perhaps if I could just work through those and indicate to your ladyship. So if we complete our own mapping exercise, as it were, the court, bear with me for a moment, the message that's here that, lady, that is not on the record.
I see.
Can I read it?
Yes. Wait, just hold on. Perhaps you shouldn't read anything that's not on record. I don't want to prejudice any parties. You see?
I think it is on record. They're going to look for it, lady. I won't read it until...
Well, the applicant did mention something about World Heritage Site or National Heritage. That's why I'm engaging the applicant as to the way forward should the court be against the applicant for that matter. And what I actually also try to establish, if this court goes against the applicant may just have another opportunity to approach the court to stop the project, should this court go against the applicant. The applicant may have another opportunity once the South African Heritage decision is made. The South African Heritage Council decision is made.
They can't afford to pay me, so... So
it will most certainly not then be the end. This is what the applicant is telling the court now. It won't be the end of the road if this court must go against the applicant.
Well, I think realistically it will be the end of the road. The construction is proceeding at pace.
Yeah.
And the notion that the respondents have conveyed that those buildings are going to get put up and then knocked down when the review application is won, it ain't going to happen with respect, my lady. It's just not conceivable, and the submission is completely inconsistent with the Camps Bay Residents and Ratepayers judgment versus Augustino, I think it is, that I referred your ladyship to. They talk about the problem of the developer building themselves into an absolutely impregnable decision where they start dictating outcomes and creating a situation of bias in their favor. And that's exactly the situation that we're faced with here.
Because the review court can ultimately decide, look, there were the irregularities, but ultimately where we are now today, the court is not going to
Indeed,
interfere.
lady. Particularly given the broad discretion under
Yes.
Section 8 of PAJA.
So the
With respect-
applicant is saying the court, it's in the applicant's interest and in the interest of the protection of their cultural heritage to rather stop it.
Indeed, lady.
The court and the court would like to assure the applicants that the court most certainly is mindful of the rights that are involved in this case. It's a very sensitive issue. The court is very much mindful.
As the court please.
Yes.
As the court please.
So the
Indeed,
applicant's view is rather stop the development than cause further destruction of the natural state of the property
Indeed.
at this stage. Yes.
Just to give you the reference in the record,
Yes.
where I understand it will tell us,
Volume?
it's page 751, volume, sure it's one. Volume 1, page 751.
Volume 1, page
Page 751.
751. Yes.
And, I'm sure it's it. It says, however, the area was signed off by President Cyril Ramaphosa and the Cabinet in August 2020 as part of the Khoi and San National Liberation and Resistance Route. The Department of Arts and Culture has also tried to have it added to an updated tentative UNESCO list as a World Heritage Site. So, lady, to come back to the mapping under paragraph A, the next place we need to go to is the supplement.
Can you just pause one moment? Is are the applicants saying that the mapping would have enhanced the significance of the property in question?
Not enhanced the significance, but better revealed and made accessible for a decision-making process the significance. So if your ladyship can then turn to Annexure LL15 at page 237.
Which volume would that be?
It'll be in one, lady.
What's volume 1? Yeah. L.
It's page 237, and it's Annexure LL15.
It's actually volume 1.1. Oops. Page?
237, lady.
Yeah, I'm working here. 2 to 6. Thank you.
And your ladyship will see the first illustration 3. This is the first additional map/diagram that's provided with the supplement.
Yes.
And your ladyship will see the area marked. Again, it's devoid of any actual mapping of heritage resources, tangible or intangible. And one can see there the site, but there's just nothing there. And they confirm that, in fact, it isn't what paragraph A envisages. They say, this diagram was not included in the HIA because several of the gradings of the site are wrong or outdated. For example, the so-called Black River, it looks like off-something site, is shown as a sports ground, and the SAAO site, 237, yes, my lady. So just the paragraph below the diagram.
Oh, I see.
So the long and the short of it is they say, here's a diagram, but it's not a diagram that works for paragraph A. Then, second, we copy here Atwell and Jacobs' composite diagram of heritage, potentially sensitive sites and heritage resources, which implies a rather different set of criteria, I think it is. And if we turn the page, it says illustration 4, identification of heritage resources, Atwell and
I'm
Jacobs.
not with you. Sorry, I lost you somehow.
I'm on page 238, lady.
2?
238, the next page.
Oh, yeah, I see the diagram, yes.
And again, one sees there's a circle, but it's empty. There's no mapping, and they confirm this diagram was not included or referred to in the HA because we think the diagram does not identify or capture the significances of the heritage resources for the area. Then, if we can go to the diagram below it, illustration 5, tangible and some intangible heritage resources. And again, if we look at the circle in the site, we see nothing specifically mapped as far as the site is concerned. And again, it's confirmed that as Postlethwaite's study dates from September 2019, it is self-evident that its findings could not be included in our HI of 2 July 2019. And so on. But essentially, all they do is to confirm that it simply doesn't apply. So, lady, that's by way of the compliance with paragraph A, which you asked me to indicate where there was a shortfall, and that certainly is the first failure. If I can then jump around a little bit and look at paragraph F, there are two aspects we focus on in relation to paragraph F, and just to refresh our memories, paragraph F is the one that says if heritage resources will be adversely affected by the proposed development, the consideration of alternatives. And we respectfully ask you already to look carefully at the wording of that provision, especially the first part of it. If heritage resources will be adversely affected by the proposed development, the consideration of alternatives. And we would submit that certainly if one considers the fact that expropriation is expressly provided for in the statute, and we say that on a proper reading of that provision, if they're going to be impacted, look for alternatives. In other words, we say the clear meaning must be alternatives that won't involve a negative impact on heritage resources or the least possible impact on heritage resources. And it says that you've got to look at what those might be. And we say, in addition, that one must interpret that provision purposively and in a manner that promotes the spirit, purport, and objects of the Bill of Rights, and a purposive methodology of interpretation. And on that basis, we submit that one certainly has to look at, as a statutory obligation, what the alternative protection measures are under the statute. And there's a range of them, a range of different declarations. There, as I've indicated, it's been suggested that it was a flight of fancy. We suggest that expropriation is a realistic alternative. It's private land. It means that the owners aren't prejudiced by a simple declaration. They get compensated for something that perhaps gets frozen. And the state can then do something there. And with respect, the law is clear that one can't interpret a statute on the basis that the state can't use its provisions. The court must interpret the statute on the understanding that the legislation can be operatively applied. Significant that when it comes to, in this context, that when it comes to the rivers, the respondents enthusiastically support the restoration of the Lesbiac Canal to something as close as possible to its natural state, despite being degraded and all of that stuff, great big concrete wall. They say it's fine, restore it, and it can become, you can declare it as a specially protected heritage area. We say, in principle, if you can do it for such a degraded canal, why can't you do it for the degraded land that goes next to the canal? Lady, the second component of the consideration of alternatives is this. The consideration of alternatives whether in terms of section 38.3f, and it's important to bear in mind that it was suggested, I think, during argument from the first respondent, that the alternatives one is talking about here is the alternatives under the EIA regulations. We say no. This is a distinctive process. This Act is a 1999 statute. It predates the environmental impact assessment regulations. And we say that there's obviously, whichever one you happen to be applying, an obligation to act independently. And I've referred your ladyship to that. That would be statutorily required under this one. It's expressly required under the EIA. And each one must receive fair consideration. The pros and cons must all be conveyed in the assessment so that the provincial authorities can make a decision that is properly informed and considered from all perspectives, more especially where the development is contentious. Such an approach, we say, is excluded, and the statute is wrongly interpreted and applied when, and I won't go there again, but with reference to page 180, we saw in paragraph C the description of the professional role as being essentially to identify heritage resources and their significances and advise and assist owners to propose development that responds to the articulated significance. In the preface to the HIA, all alternatives other than the preferred development are excluded ab initio, and we're told that we think the choice is stark but clear: accept the currently proposed riverine corridor alternative with what we think are very considerable public benefits, or accept that the River Club property will remain as it is. And in the answering affidavit in these proceedings, we are told by the consultants themselves that they were engaged in finding the appropriate form of the development, quote unquote. That is not what paragraph F of the statute requires. So that, we say, is another failing that hasn't been successfully resisted by the respondents. And each of these failings on their own, because of the objectively justiciable nature of the first part of the proviso, would lead to a failure. There is then a discussion of paragraph E, and we've already had a discussion at the beginning of my argument, so I'll try and shorten what I had to say there. But there was a suggestion in argument on behalf of the fourth and fifth respondent that this particular provision imposes no self-standing consultation requirement, only a reporting requirement based on the wording. Report on the if we can just get the exact wording. So it says the results of consultation with communities affected by the proposed development and other interested parties regarding the impact of the development on heritage resources. So that results is focused on, to say you don't have to consult, you just have to give the results of consultation. We submit that there are several difficulties with that interpretation. The provision cannot have been created with the reliance on the consultation provisions in PUDGA in mind, because that is what I understood to be my learned friend's arguments, that you must source the consultation obligation in PUDGA and then report on it under this particular provision. In the first instance, PUDGA did not exist at the time of this particular statute, so that can't have been what Parliament intended. Nor can NEMA or the EIA public participation requirements be used as the basis for the consultation requirement, because Section 38.3 operates also when Section 38.8 does not apply, and the Heritage Authority is the one statutorily tasked with deciding on whether or not to allow the development. If we gave it that interpretation, compared with the EIA regulations, you'd end up without a basis for consultation. So, bearing in mind the latter scenario, it would mean that when the Heritage Authority is the decision maker on the authorization of the development, there is no statutory obligation at all. Yet there is still a reporting obligation. The section would then be complied with if the heritage practitioner simply reported there being no obligation under the statute, no consultation process was conducted. With respect, that cannot be correct. This approach to interpretation illustrates why another submission of my learned friends was wrong when they said that the amicus' submissions are irrelevant and can be ignored. With respect, my lady, that is a surprising submission to make, considered against the peremptory terms of Section 39(1)(b) of the Constitution. Must consider international law when interpreting a statute. also out of line with the approach to interpretation required by Section 39(2)(b), promote the spirit, purport, and objects. On an interpretation that respects these two constitutional duties placed on a court, an obligation to report on the consultation process means that there must be an underlying lawful, meaningful, and constitutional consultation process that must in fact take place. And to determine the content of the consultation, there's ample authority from the courts. Additionally, where any component of the consultation sought to address the position of First Nation peoples applies, it must be one that takes into account the special obligations that arise in international law when the heritage rights of First Nations community are affected. These were summarized as those requirements that I've referred to, the 6 requirements that my learned friend took us through. Only focused consultation with some First Nation peoples, as we say, was that reflected in the First Nations report, but we have already discussed that. I don't think I need to take that any further. Lady, then, remaining component, the Minister's decision, we persist in saying that the Director in his letter of the 17th of Feb 2020, that's Annexure AB4, was talking about the failure to satisfy the requirement of the appointment of and report from a specialist consultant on intangible heritage. And my learned friend said, well, if you look at the letter, it doesn't refer specifically to that requirement of appointing a specialist consultant. But if you look at paragraph 37 of the answering affidavit, although they there cast it in the terms of a recommendation, they zero in very specifically on this particular part right at the end of the letter where they say, get a specialist consultant and get a report from them. So we know from the affidavit, not from the letter, that that's what he's talking about. And then in his letter he says, comply with the requirements. And I showed your ladyship where it uses the words, twice uses the word requirements. And that's the contemporaneous document, which must be the one that's more compelling. Even if it's a recommendation, even if we take it as that, it had to be in the minister's decision because it had a big asterisk next to it. It was a strong recommendation, I think they described it as. There's nothing to suggest that the minister treated it as such. In fact, effectively he rejected it because he didn't ask for it. He bashed on without it. So that can never, we would submit, amount to taking into account. In relation to irreparable harm, we have already made submissions when we were talking about OTA. We also referred in our initial argument to the affidavit of Mr. Jenkins when he describes the disembodiment that's involved, when he describes the pain that is inherent in intangible cultural heritage, being swamped by, as your ladyship put it, a concrete jungle. So with respect, we have great difficulty seeing how it can possibly be suggested that there isn't harm going on right now as the development proceeds. Indeed, we say if the respondent's conception of intangible heritage is that it is not affected by construction of these buildings on the site, that is compelling evidence of the failure of the heritage consultants to even understand the nature of intangible heritage, let alone assess significance and impact correctly. The first respondent persists in the issue of it having been degraded. I think we've already had a discussion about that. But the part I wanted to focus on in relation to my learned friend for the first respondent submissions is he said that the way you deal with intangible heritage is to document, record, and memorialize. With respect, my lady, that cannot be. That is to ossify it. The term used for intangible heritage in the statute is living heritage. I need say no more than that would not be living heritage. We can then come to the issue of the balance of convenience. We referred to the judgment of Lord J, which I've referred to a couple of times. Just in relation to that judgment, it's in the notes. I don't need to go there in, and I've indicated what it says. But the line that's important is this one. The stronger the prospects of success in the review proceedings, i.e. the prima facie right, the greater the subordination of prejudice occasioned by a cessation of the building work. Otherwise stated, the principle of legality tends to operate decisively in this context. And that's what we say needs to happen in this case. What the learned judge is articulating is that we are a society governed by the rule of law. We are not a society governed by the rule of concrete. Although brought under PUDGA, the essence of the challenge to the NEMA decision-making process is a legality-type challenge, so we tick that box as far as that aspect of the judgment is concerned. And on an application of the principles laid down in this judgment, we say that the construction most certainly stands to be stopped. To the extent that any balancing exercise is required to be conducted, it is submitted that in the context of this matter, it is, and I think your ladyship has pointed that out appropriately with respect, it is a matter to be approached with extreme caution. The value of the constitutionally protected heritage and cultural rights which the applicants seek to protect, rights which have their origin in the birth of ancient societies and which have subsisted for millennia, should not readily be devalued in a contest with wealthy property developers with substantial funds at their disposal. Certainly in the Shell matter, anticipated losses in excess of 1.3 billion were not considered to outweigh the cultural and spiritual constitutional rights in question. This was notwithstanding that the prima facie right there was at the weaker end of the spectrum compared to the right in the present matter. The response of the applicants in respect to the claims by the first respondent regarding the balance of convenience are dealt with in detail in the replying affidavit and annexes at page 2635 to 2644 of volume 7. Again, those references are in the notes. The replying affidavit includes an analysis of the relevant provisions of the development agreement with Amazon Development Company. We highlight the following as far as that is concerned. The first respondent bound itself to an extremely tight construction program for completion of the development before any of the environmental authorization and land use planning permissions had been granted. This is so despite the fact that it is clear from the terms of the development agreement that both parties understood that there was considerable uncertainty attendant upon the timetable, and they purported to structure their agreement accordingly. The development agreement provided for two junctures, two opportunities, at which the developer could assess the viability of the contractual timetable and exit the agreement without incurring penalties. The first respondent elected at their own risk to proceed, and the first respondent has not explained why at those junctures the litigation risk was not factored in. The parties were in any event able to negotiate an extension of 5 months in respect of the agreed practical completion date and lease commencement date. Despite provision for extensions also arising from COVID delays, the first respondent asserts that they simply absorbed those. Why? Following further submissions are made in this regard. Paragraph 79, page 845, volume 3, it is stated that Amazon Development Company recently agreed to reset the practical completion date and consequently the lease commencement date to the dates of 30 November and 1 December. Again, no explanation given as to why the parties did not factor in judicial review proceedings. Insofar as litigation delays are relied upon, there is no reason why the parties should not ensure that the further review, hearing, and any appeal is conducted on an expedited basis. We've discussed that. Importantly, the definition of anticipated practical completion date in clause 2.1.3 of the development agreement commences with the words unless otherwise agreed by the tenant in writing. In those circumstances and with no affidavit from them, there can be no reliance on assertions by the first respondent as to how Amazon Development Company will use that clause, will react to that clause. The option is certainly open to them to accommodate a review, particularly an expedited review. And I won't take your ladyship there, but I would commend to you clause 2.1.3 of the development agreement. It is submitted that this court should be slow to deny the applicants protection of their constitutional rights on the say-so of Mr. Aufrichter, and in the absence of any full disclosure by both him and Amazon in this regard. Absent that, the word of Mr. Aufrichter is dictating the extent to which the Bill of Rights does or does not apply. The public interest component of the balance of convenience is dealt with at paragraphs 128 to 141, page 2644 to 2650. And Summit has pointed out there that Amazon is committed to commissioning the development of a campus in Cape Town, and if it does not go ahead on the River Club site, it will go ahead at one of a number of other potential suitable sites. The events surrounding the Vogue development cannot support the case that the city seeks to make out in relation to it, and that has been adequately explained in the replying affidavit. property development companies are well aware of the risk and costs associated with delays in obtaining the necessary approvals, and those are higher when one has, as here, a site that requires rezoning, departures from land use planning policies, site has specific ecological or heritage qualities, and there is a high degree of public opposition to the proposed development. And you will hear my learned friends proceeding on the assumption that it automatically works for the city and its citizens that the construction should go ahead. One has to take into account what the consultants say, that virtually all the comments were against, were negative, were objecting to it. So there's a significant portion of the citizenry who are not in support of the development. In relation to the absence of an adequate alternative remedy, it is clear from the decided cases, including the Shell case, that the appropriate manner of proceeding in circumstances such as the present is to apply for a judicial review of the relevant decisions and at the same time seek urgent interim relief, preventing further construction or the continuation of any other offending activity. The first respondent cites no authority for an urgent review being an alternative remedy to an interim interdict. In any event, we have here today offered them one. The applicant in the letter of the 11th of May in effect offered an urgent review linking holding off on construction with subjecting it to a deadline for commencement, and the first respondent rejected that. Insofar as the issue of urgency is concerned, I think that that's been adequately debated. I see that we are running out of time, milady. Can I do the following in respect of the strikeout applications? Obviously, in respect of the review grounds that came in the reply in respect of the city, we don't oppose the strikeout, but we would ask if your ladyship makes an order to strike it out notionally for the purposes of these proceedings, because there can be no prejudice if it stays in for purposes of the ultimate review proceedings, because there's going to be an opportunity to file a further answering affidavit.
Only you say that the applicants concede that.
Applicant concedes that. I think it's, if I remember correctly, it's paragraphs 85 to 90 and paragraph 99, if I remember correctly.
Can I get those references again, please?
I'm told not 99, it's 85 to 90, milady.
85 to 90.
85 to 90. Lady, the two, in relation to the strikeouts, if I can just mention, I won't go through them, and again, they're in that note. The two judgments that we rely on are Botswana is the one, and that's a Gauteng South judgment, and the other is Hydrotech Systems Pty Limited. That's a decision of this court. And essentially, the point that they make is that a party is entitled in their replying affidavits to take up an issue that was less substantially pleaded in the founding affidavit once they see that the issue becomes a contentious one. It's impossible for an applicant to be prescient as to what is or isn't going to be taken up. There's just one specific aspect that is important in relation to the issue of the specialist report. If your ladyship can just take a look at paragraphs 91 and 92 at page 55 of volume 1. There's an attempt to strike out a wide swath of matter relating to whether Mr. Orenser was an expert and whether his report was a report as envisaged and required we submit by Heritage Western Cape. And then there's a strikeout application on the basis that we never made that part of our case. If we look at paragraph 91, about halfway down, it says, the Heritage Western Cape's overriding concern was that the second HIA had not accounted for the intangible significance of the site flowing from its historical associations, and that the assessment was consequently flawed. The interim comment concluded with the recommendation that a specialist consultant with expertise in intangible heritage should be engaged to provide a supplementary report. And then the important paragraph is 92, and the word that it begins with. It says, instead, the LLPT caused a supplementary report to be submitted in December 2019, which was prepared by the same authors as the second HIA and essentially re-argued its conclusions. A copy of relevant sections of the supplementary report are attached. The supplementary report also included, and so it goes on. And if one looks at the response to that, my lady, of the first respondent, I'm not immediately finding it, Lady, but I'll describe it, and we can look for the reference. Essentially, what happens is they say that they dispute that. They put up a curriculum vitae of Mr. Orenser, and it's quite clear from their response to those particular two paragraphs that they have understood the allegation that's made. That's why they attach his curriculum vitae. That's why his curriculum vitae has those top two lines. And with respect, on the basis of the two judgments that I've referred to, we're then into a legitimate debate on those two judgments in the replying affidavit. Responses at 898, volume 3. At paragraph 92, it's at some length. Given that the First Nations parties approached by the heritage consultants during the public consultation process elected not to submit comments on the draft when it was circulated, it was accepted that the HIA could be improved in that respect. As a consequence and in an abundance of caution, the LLPT implemented the recommendation of Heritage Western Cape in its interim comments and duly appointed a specialist consultant with expertise in intangible heritage. So they can see the debate is on as far as that issue is concerned. And then it's legitimate to put up an affidavit by Prince Solani, which then takes the issue further. In, I think it was the high-tech judgment, they took an auditor who hadn't, a forensic auditor who hadn't given any initial affidavit, and she looked at the financial statements put up in the answering affidavits and analyzed them and produced a report. And they said, that's okay. We say this falls under the same category, and for that reason should not be struck. So, lady, we submit that, save in respect to those paragraphs, the strikeout application should be dismissed. But I'm not sure what your position is in relation to timing. That was the response I prepared to the first and to the fourth and fifth respondents. The cities I only heard this morning, and so I can do my best to try and whip through as much of that as I can. I'm not sure if your ladyship would like me to proceed.
The court cannot stop you. The court will give you your full hearing. Yeah?
As the court pleases, my lady. I'll try and keep it brief. One of the submissions my learned friend made is that the decision makers considered and decided that those buildings will not harm intangible heritage. We say that's irrelevant, that decision-making process took place for purposes of assessing irreparable harm and the balance of convenience. With respect, that's your ladyship's assessment in these proceedings. The notion that we said that the only thing we want is a right to a judicial review is not correct. I subsequently elaborated upon that substantially. We've dealt with the golf course on the site. We've dealt with the issue, your ladyship has raised the issue of whether the applicants took any steps to protect, and I've answered that. in relation to the issue of there being consultation on the planning of the buildings that are allowed to go ahead with respect, that obviously isn't a solution from the perspective of the applicants. We would respectfully support the proposition that was put to your ladyship that there's a difficulty with trying to attach an economic value to intangible and tangible heritage resources. They're essentially priceless. We've dealt with the issue of the pending review proceedings and whether or not those will be a source of delay. There was a submission that we have the advantage here that the developer has said that they are proceeding at their own, has accepted they are proceeding at their own risk, and therefore that they can be ordered to knock it down. We've debated that, my lady. That's not in the real world. In the real world, those buildings, once they're up, are going nowhere. There's a suggestion or an argument that the shifting nature of the case and it has collapsed. Yes, we acknowledged and readily accepted that there was a difficulty with the refinement of the review grounds. We've made our position clear as far as that is concerned. We don't think that that is such an unusual circumstance. One had exactly the same circumstance that, perhaps exactly as overstating it. One had a similar circumstance in the Shell case. We think worse, in fact, because there it seemed crucial to the survival of or prevention of the collapse of that particular case that they had to get a judicial review going in respect of the exploration right, which they hadn't done at all. There wasn't even a review. And that didn't deter the court, as the court gave them the assurance that they would do that. And important, and it's a crucial fact from a number of these perspectives, including the perspective around costs, milady, is we're sitting here in a situation where it's not an ordinary proceeding where the next, it's the end of the case once the replying affidavits are filed. There are going to be opportunities for us to file another affidavit, to amend. Always happens in a review. Invariably, you change your review grounds, supplement them, change them, chop and change, amend your notice of motion. And the fact that you can amend your notice of motion shows the kind of leeway that the rules envisage in terms of refining your case and taking it forward. And we've indicated the basis on which we say we're likely to reformulate the case against the city. We've dealt with the issue of participation as a review ground, and we have dealt with, and also my notes refers to exclusions. In relation to the eighth respondent, there's a suggestion that the arrangement that is in place in respect of the development of the site for First Nations, as far as First Nations is concerned, is one that gives effect to the right of return. In fact, the right of return is something which is increasingly the subject matter of international law, and it's well recognized in international law that the right of return means what it says. You go back and you go and live at the place where you were before you were dispossessed of your land. So by no stretch of the imagination is the current arrangement the restoration of a right of return. Bear with me, and the relief that we ask. I'll just go back in in my notes. So in conclusion, we say that the strikeout stands to be dismissed, save in respect of those paragraphs. If the strikeouts are granted, we submit it should be that it is only for the purpose of the interim
Sorry,
interdict.
can you just start again? The strikeout application
Should be dismissed, save in respect of the paragraphs that I have conceded. Even if the strikeout applications were all to be granted, the applicants we submit have made out a case for the relief sought on the papers as they would then stand. In all the circumstances, it is submitted that the applicants have made out a case for the grant of the relief sought in Part A of the notice of motion. Applicant does not persist in the relief sought in paragraph 2.2 of Part A of the notice of motion. The applicants were forced by the conduct of the first respondent to bring the Part A relief. They have been supported in their prima facie unlawful conduct and in resisting
The applicants abandoned the relief sought in paragraph 2.2.
2.2, yes, Maggie. I think it was linked to the provisional protection issue.
Yes, yes.
We say that they've been supported in their, developers have been supported in their prima facie unlawful conduct and in resisting the interim interdict proceedings by the remaining respondents. In the circumstances, the respondents will be ordered to pay the applicant's costs, such costs to include the costs of two counsel jointly and severally, the one paying the other to be allowed, and it would be consistent with the relevant provisions of NEMA, and in terms of the relevant provisions of NEMA, I should say. We submit that the cost orders sought by two governments and a wealthy developer against a civic association and a group of vulnerable First Nation people would ruin them financially. It would in effect destroy them as organizations. Although not entirely on all fours with this matter, we submit that your ladyship's judgment in mineral sands stands in the way of a costs order of that nature being granted, although the circumstances were slightly different. The effect of a cost order that is in conflict with BioWatch may well force the applicants to proceed with an appeal, which is not a scenario that I think is necessarily in anybody's interests if they were minded on that in those circumstances not to do so. The basis for the bypassing of BioWatch was primarily, as I understood my learned friend's argument, pointed to on the basis that they weren't asserting a constitutional right. That argument has been dealt with, and if your ladyship is with us on the argument that they're asserting a constitutional right, there certainly hasn't been anything like the kind of conduct that is envisaged as depriving one of the protection of an order in BioWatch. In addition, they have the protection of the relevant, I haven't immediately got a chart, I think it's section 33.102 of NEMA. The applicants have done a real service for society. The heritage consultants acknowledged that almost all comments on the development were in opposition to it. They were willing to come forward and do something about it and effectively represent both civil society and those Khoi groups who do not go along with the development. They have paid a heavy price. Mr. Jenkins had to take out a protection order as a result of his involvement in these proceedings. That's at page 731 of the record, at paragraph 53 of his affidavit. He and the second applicant have been most inappropriately attacked and vilified in the affidavit filed by the eighth respondent in the ways that echo those of the Orense report. We submit that was a complete abuse of the legal privilege that attaches to court documents and is a factor to be taken strongly into account in not making any cost order against them in the event that the court is against us. As the Constitutional Court recognized in BioWatch, it is groups such as the applicants that breathe life into the Constitution. Snuff them out, as the respondents clearly wish to do, and you snuff the life out of the Constitution itself. Lady, you would like to put up the analysis that I was reading from the laptop of who the other source within the record of the list of people we say weren't consulted, yes, on a simple...
The court reconsidered its position. The court will just determine the matter on the papers I am withdrawing my request for any additional notes in this matter. It may just set in motion something that the court did not. There may be unintended consequences should the court
This-
receive any note from anyone. So I'm withdrawing my request for any notes. The matter will be determined on the papers as it stands.
This is on the papers, Milady,
As long as it's on the papers, you're welcome to.
as
Raise it.
the court pleases. Those are the submissions in reply on behalf of.
What did
the
you refer
applicants.
to? Is there anything you wanted to refer the court to that's on the papers? What are you referring to? The list of the groups who,
Who are reflected in the appeal in relation to the provisional
Yes.
protection,
yes,
as the court pleases.
Thank you very
Thank you
much.
for bearing with me, Milady, and going past time
yeah,
on
no
a Friday.
problem. Thank you very much to all the parties. Your heads are indeed very valuable in this matter. The court will need time to consider this matter. I will try to give priority to it. It is an urgent application. Judgment is then reserved. Thank you very much, everyone.